Said slow down, they said fall back, but the doubts hit the tank and it's all high octane gas. Let's go, yeah, we run it up clean. Funny thing about the hate is it fuels the machine. Let's go, all bark, no bite, no teeth, while they're stuck in the comments with 10 steps past belief. Eyes locked, no breaks, no pause. Every shot they take just reminds us who we are. We don't beg, we don't fold. If they're watching this mad, yeah, the plan's still gold. So talk it out, type it slow. Every hater in the crowd just helps the engine go. No fade out, no laying low. Fueled by the hate, still winning though, yeah. Yeah. Roll it back, run it up, save energy, let's go. Let's go.
And welcome to Petty Playback, where just like Kathy Nestor, everything has gone to absolute shits. And yeah, so let's see what the defense has in store for us today. Just like YouTube, everything has gone to hell in a handbasket. Hold on. And the little wants her blanket, and she's throwing a hissy fit until she gets it. Somebody's got a major attitude issue today, and it's not just me.
Everybody's tired of Nesta.
However, YouTube did limit my stream from yesterday morning, as I figured they would,
Did that mean you
due
monetized?
to the content and my personality. So if y'all want to send those super chats today, please go ahead and do that, because y'all, just a thing.
Why they demonetize you?
Huh?
Why they demonetize you?
Just, I'm dangerous. I'm something. I'm just here. So we are going to continue day 2 of yesterday's wonderful stuff. We are 5 hours and 17 minutes into an 8.5 hour stream, and we are going to do our best to get through this absolute fucking nightmare as fast as possible, because your girl is doing laundry. I have more appliance deliveries today. I don't have to work, but I do have to make dinner. I am fasting for part of the day today, so I am hangry, which is just helping my cause. But I am in severe pain in my knees and my ankles, and I'm really hoping that being dehydrated and limit or not eating a lot of protein recently, being dehydrated and eating more sugar than normal, has contributed to my pain levels, which I'm really hoping like an 18 to 20 hour fast will help reduce the inflammation in my legs, and not make me so damn uncomfortable and in pain. So I am having a bad pain day. So if you see me wince, move around a little bit, or be just a little bit more bitchy than normal, which I know is a high threshold to meet anyway, y'all bear with me, because we are just a little bit in pain today.
At least you have a good reason for fasting. I know in January the church was fasting, and my aunt like, we're doing 21 days of fasting. You want to do? I said, you know that's not gonna work for me. I can't go 21 days without eating. I can't go 2 hours without eating.
I feel so much better when I do 24 hours, but I hit that like 15 hours and I'm like, oh, But I think it's more of a habit than actually being hungry. But we're gonna share this stream. If you see me leave, it's either mama duties or wifey duties of I have to switch over my laundry. You will occasionally see me folding my laundry. Welcome to trial streaming with me. I fold laundry while I watch because
Yeah, most of
it's
y'all
gotta
who
get
wasn't
done.
most of y'all who wasn't here when she did string trials on the regular, that's what you saw on stream. So
Real life does not stop for trials. And my laundry does not stop for trials. Heidel, thanks for being my super mod. Jeffrey, good to see you. Christine, good to see you. Yeah, Heidel, I messed up. I sent Flash the wrong link, and bleh. But I fixed it. Hopefully, hopefully, and Jeff, thanks for being amazing as usual. Holy shit! See, it only says new Kofi bot, new tip from Jeff on there. It doesn't say the thing, so I have to look at it. $200 starting us off with a yeah, and I forgot to order my shit yesterday. So like I actually forgot to buy the stuff for my kitchen yesterday. I have to do that today. Well, I got the appliances and
oh, the dishes. That's right. That's right.
the stuff that I accidentally sent away with my old stove, which Mr. Squid in he was like, it was old anyway. It needed to be replaced. I guess we're just gonna have to buy new stuff. But
DC didn't like. Oh man, you gave our stuff away.
But I am the kind of person that like it is the lowest on the totem pole of stuff to be replaced because one, we don't use it very often. I haven't made muffins in like a year. Also, it works. And I don't like replacing stuff that works.
Yeah. You like what my boss philosophy was, if it ain't broke, don't fix it. If it ain't nothing wrong with it, don't replace it.
That's my mentality of like, yes, we're doing the appliances and yes, they work. However, there's mismatched appliances for my house being new. It's mismatched appliances and there's just some like
I was
the appliances came with the house and they weren't what I would have bought. So, yes, I looked up the bakeware, I added them to the cart and I forgot to actually hit purchase. So that is on the agenda for today.
I was laughing when you said dishes since 2020, and people were putting in chat like dishes. I had dishes since 1999.
Well, we do have like bakeware that is like I would call it vintage because it belonged to Mr. Squid's grandfather. Like we have stuff in the house that is, but like this is stuff that like cheap ass cookie sheets from Walmart from 2020 that when you make so many biscuits on them, the enamel starts wearing off and like they're just not they're like the stuff that you cook like frozen cookies on. They're not the good stuff.
Yeah. That kind of like my aunt when my uncle passed. She would get rid of. He had cookware that his mother had since the '60s. She's like, yeah, I'm not gonna be able to use all this. My uncle was kind of a hoarder when it came to that type of stuff.
And that's different than the cheap the $5 cookie sheet that I bought from Walmart in 2020 that the nonstick is coming off. Like that kind of stuff. It's like, yeah, it works, but it could be replaced. Yeah, it's not the nice aluminum like Nordic ware pans that I have for my, sugar cookies when I actually bake the good shit, So, hello. How are you? All right, we're going to get started on this because thanks for letting me get my rant out. I hope y'all are having a good day. It's just busy and it's just like every day is just busy. Yes, parchment paper, Jeffrey. I have silicone sheets that I put over my good aluminum half sheet pans That is my good. We are talking the stuff I sent away with my stuff on my stove yesterday was like the bottom of the barrel, like the crap you use on a Tuesday night when you just need to throw in a frozen pizza, like that kind of stuff. Not the I'm cooking for, my family, like we have guests over, not that stuff. Like this is the everyday use it till it's destroyed stuff. Well, it was on the destroyed side. So it's not the stuff that is it
Just-
needed to be replaced anyway. It was just the lowest thing on the totem pole on the list of priorities to replace. So it's like I'm not mad that I sent it away and that I need to replace it. It's just kind of I feel like an idiot for not checking that anything was in that drawer before I let them take the stove. And now they're probably wondering why it was so damn heavy. So,
Just
all right.
I gotta know. Since you missed streaming this hearing for like 3 days, do you miss trial streaming?
Yes and no. I do miss my speed play at night because
Night court.
there was night court because things were different at night because there was not a lot of other stuff going on at night and not a lot of people trial streamed at night. So it was different than everybody streaming during the day, but I got to do what I got to do to get by. So, but look at the judge's face. All right, we're going to get started. This is just after lunch.
Yeah.
Mr. McBride, turning to the state.
Yes, Your Honor. Just by way of preview, we are going to call Jen Falmuina, Sergeant with the SBI, but how we're going to proceed is we're going to call her for a very limited purpose. We're going to pause her testimony. Defense is not going to cross at that time, and we're going to call an FBI DNA analyst out of order as a defense witness, but that's to accommodate the witness schedule. State calls Sergeant Jen Falmuina.
Like to come forward
Interesting.
and be sworn in?
I am interested to see what the defense had with these experts. So that should be interesting.
I mean,
All right. After you're situated, there should be a bottle of water to your left, maybe behind the monitor. And if you wouldn't mind just bringing that microphone just a little bit closer to you so it picks up your voice for the recording. Mr. McBride, your witness.
Will you please state your name?
Yes, Jennifer Famuina.
Where do you work?
I work for the Utah Department of Public Safety.
What position do you hold there?
I'm currently a sergeant within the State Bureau of Investigation.
What was your assignment September 10th, 2025?
I was assigned to oversee the crime scenes as well as the physical evidence.
And were you sergeant with the State Bureau of Investigation at that time as well?
Yes.
And do you have any kind of specialty in your assignment there?
Yes, I do. I am currently overseeing, or I am the lead over our evidence response team within our division. That includes not only conducting training, but also attending training and whatnot.
Okay. So if we hear ERT, it means Evidence Response Team.
Yes.
Were you called to the crime scene at Utah Valley University on September 10th, 2025?
Yes, I was.
And were there multiple scenes that you oversaw or helped process?
Yes.
We've had some testimony about the rooftop of the Low C Center. Did you oversee or are you aware of evidence that was collected in that area?
Yes, I am.
Was there a screwdriver that was collected from that rooftop?
Yes.
And do you know how that was collected and what happened to that screwdriver?
Yes, that was collected by the Utah Bureau of Forensic Services Crime Scene Response Team, or also known as our State Crime Lab.
And do you know what happens to that?
Yes, it was packaged, and then that evening there was discussion on who would take custody of the evidence, and I was there along with FBI. Then it was decided that FBI would take custody.
And did that evidence actually go to the FBI?
Yes, it did.
And was it sent for testing?
Yes, it was.
Where was it sent? Do you know?
It was sent back to their equivalent of our crime lab.
Okay. Are there other areas there at Utah Valley University that were also processed for the presence of evidence?
Yes, there was.
Is there a wooded area that's northeast of campus?
Yes.
What was found in that wooded area?
What was found there was a long.
just for reference, we are at 1.5 speed. These two talk a little bit faster than like the rest of the courtroom.
Yeah.
So if it is a little fast for people, let me know. However, I am not feeling the need to interrupt much here because she's a very straight to the point witness.
Yeah. It seemed like they said the limited purpose. The thing is, seemed like this just like foundational evidence collecting.
Well,
So
the
I was-
screwdriver, I think, is important with the weapon and the disassembly process.
What the
but
what the
that's just-
weapon? I can't remember if it testified to yet. What the weapon ever recovered or?
Yeah,
Okay, all right.
it was his grandfather's weapon. So
Oh,
there's
okay.
also like people are like, well, there's multiple people's DNA on the weapon. Yeah, because the weapon wasn't his. And honestly, on my weapon, there's multiple people's DNA on it because I live in a house with multiple people.
Now I did see a clip, and I'm not going to reveal what the clip said, but it caught me by surprise. I'm like, oh, because I don't know that it was testified to yet about. Well, maybe you know, maybe they talked about it before, but the new clip said something about the roommate's DNA being found.
The thing about it is, so the thing about a weapon is if someone ever touched it, it could have their DNA on it. That doesn't mean they ever shot it.
Yeah.
If they ever touched it. So I could go into our safe right now and try to get one of my my hunting rifle. And go to get my hunting rifle, and I move Mr. Squid's hunting rifle out of the way to get mine. My DNA is on his rifle. I never shot it.
Yeah.
But my DNA is potentially still on it. So it's like it.
Yeah. And that's just how DNA works in general. From what I understand, you touch something or you have a bottle, when multiple people touch it, it's gonna be.
You could leave DNA behind. You could leave it like, and so when people say, "Oh, his DNA is on it," more people's DNA. Well, he didn't own this weapon; it was his grandfather's, and because it was his grandfather's, and it was kind of an older weapon, who knows when the last time it was cleaned?
Yeah.
So, and that's another
remember-
reason why I think he missed. Who knows when that weapon was cleaned last?
I gotta remember to stop listening to the media. They play stuff up there, probably not even really that big.
Well, they take. The thing about it is sometimes what they say isn't inaccurate.
Yeah.
However, when you add the context of, yes, I see, baby. When you say, it sounds bad when you say, oh, somebody else's DNA was on the weapon. It sounds like this big headline, breaking news. But when you think about it and you place it in a context of it was in a safe with multiple other issues or with multiple other people's stuff, and someone moved it, or it was in a closet with other people's stuff and they moved it out of the way to get something of theirs.
I mean,
All
everybody
they have to do is touch it for their DNA to be on it. It's not like
what happened in court, especially for this case. It was a dude who streams cases in general, and his video title was prosecution detective humiliated by defense. I'm like, the defense didn't humiliate anybody. You watch that cross-examination.
Yeah, like I just hate the media because they take something and they take advantage of the people that, one, don't pay attention or don't know the context, or they take advantage of people's ignorance that don't think about. And when you logic it out, it there could be a simple explanation for things, but people want to sensationalize crap, and that's where the media takes advantage because, oh, multiple people's DNA. Well, yeah, his roommate could have there's a closet right here. That rifle could have been sitting in a closet, and it could have been leaning up against something that the roommate owned, and therefore the roommate's DNA that was on the other touch DNA is not, or the roommate needed to get something and moved the rifle and grabbed the barrel and moved the rifle. Like, that's all it takes for you to get fingerprints and possible skin cells on. It's like when you logic it out, it makes my brain just explode with like, what the actual hell? Because unless you see where the DNA was, if what the DNA was it skin cells? Was it blood? Was it like, there's different kinds of DNA. Like, was it saliva? Like, what was it? It could be a simple explanation that does not.
They really interest me in the cases when it comes to cold cases, because I'm like, all right, that DNA wasn't very popular with some of these cases. These crimes were committed. So I'm like, yeah, I want to know what you have, and I'm gonna scrutinize DNA. when they say it's other people's DNA there.
Yeah, using logic on the internet is scary.
Apparently so. More to than local Utah news media.
I mean, yeah. So we're gonna get back into it, but it's one of those things of like, y'all, when you hear a headline, and that's why it's like think before you react. That's kind of the tagline, and like the motto for this channel is think before you react. Because if you just react based on your emotion, you're gonna play into the media's what they want and their narrative. And it's like sometimes their narrative is like, well, once you read past the headline, their narrative falls apart.
Yeah,
but they count on people not reading past the headline.
I would read articles about like court case and the hearing or the trial is streamed. I'm like, what the heck is they talking? That's not what was said.
And Anima Rumpier brings a really good point. The location of the DNA is just as, if not more important than the fact it's present at all. If it's on the end of the barrel and not the trigger, it makes a huge difference. It's a really good point as well. And they don't ever seem to mention where the DNA is in these articles, and that's also very interesting to me. But we're going to get restarted on this.
Yep.
I'm going to slow it down to 1.45 because they talk just a little.
I guess I think it is going a little bit too fast.
Yeah, she reminds me of an old friend of mine that she just straight to the point, and but very like, she looks like a friend of mine too, which was like interesting.
So. You sure it ain't the same person?
No, it's not the same person. Although this person does live in Arizona now, so. But
Long gun that was wrapped in a dark colored towel.
And you say a long gun. What does that mean? A long gun?
Sorry, that would be a rifle. So for to be more specific, it was a Mauser 98 rifle.
Do you know what caliber that was?
It was retrofitted to a 30-06 barrel.
And do you know what kind of action that had? Was that a semi-automatic, automatic, bolt
It was
action?
a bolt action.
What is a bolt action rifle?
I'm not too familiar with guns, but I just know there's a bolt and you have to pull it back.
Okay. And what was done with that weapon and that towel?
That was documented in place, and then eventually pictures were taken. It was documented in place, and then afterwards we rendered that gun safe and then packaged the gun as well as the towel.
What was done with the towel after it was packaged?
The towel was also provided to the FBI.
And those two items, well, let me tie up that thread. The gun, what was done with the gun?
The gun was packaged. It was taken to FBI custody, then eventually it was provided to the ATF lab.
Okay, so the gun went to the ATF lab. Is that correct?
Yes.
The towel went to the FBI lab.
Yes.
And the screwdriver went to the FBI lab.
Yes.
Did you receive reports back from testing that had been done on those items?
Yes, I did.
I'd like to show you State's Exhibit 31.
I mean, yes, you're going to object to this probably.
probably. And I will be skipping objections because
Becky is the same one. Here's the
Freedom. I think that's connected to the defense computer right now. Is there any way to switch it? Thank you. Okay, I'm showing you here on the screen State's Exhibit 31. Do you recognize that?
Yes, I do.
What is that?
This is the FBI report that was provided to me by the FBI that documents DNA testing.
And does that include testing that was done on the screwdriver that we've spoken about and the towel that we have spoken about?
Yes, it does.
Okay, what I'd like you to do, Kimberly, if you'd please just scroll down so that Sergeant Falmouina can observe this exhibit.
Who?
probably the
If I can have just a moment.
courtroom, the audiovisual person for the courtroom. So I will have to do mama duties and laundry duty in a minute. So
Yep.
trust your ability to skip. Yeah. And touch DNA small fragments and degradation is concerned whether sunlight, various other factors shorten the
Can you see who that
approximate
report is
1-year
signed
shelf
by?
life.
Yes.
Unlike DNA
Who's
from
that?
saliva, blood, hair.
Amanda Baker, I'm assuming is how you pronounce your last name.
Is that, in fact, the report that you received documenting the testing results on these items and some other items from
Yes.
the FBI?
Sorry, yes,
And does it appear to be in an accurate condition as to how you received it?
yes.
I'd move the admission of State's Exhibit 31.
Defense?
No additional objections.
All right, so I'll note the standing objection, and as it relates to admission,
Oh,
what is
Michael
your request
Burke
as to
like
publication?
I'd move this admission and its publication both to the court and to the public.
All right. Anything further, Mr. Burke? All right. The court will admit State's Exhibit 31 into evidence and allow publication of this exhibit to the gallery and to the monitor on screen in the courtroom and for the camera to broadcast.
Okay, if you'll go to, Kimberly, if you'll scroll down to, still on page 1, where the screen will show items 7 and 8. Sergeant Falmuina, do you see the lines there that say item 7, that line?
Yes.
And will you read that portion of the report that describes what item 7 is?
Item 7, towel from around Mauser rifle, serial number 8863.
And there's also some other identification numbers. Is that the towel that you found with the rifle that day?
Yes, it
On
is.
September 10th?
Yes.
Item 8, will you read what that says is a description of item 8?
Item 8, screwdriver from perch.
And is that the screwdriver that you described that was collected from the rooftop?
Yes.
Okay. If we can go to page 3 of 6, please. Will you, item 7, sub 1, will you please read the result there from the title item 7 until the word contributors?
I'm going to object to that. It's cumulative. We have the analysts here for being so not sure this is the court be having her read from the report.
And, would you mind repeating that, but with the microphone? I want to make sure that the record
Yeah.
picks up your objection.
Use the microphone, damn it.
All right. Either way, if you want to come up, that's fine, Mr. Burke.
Judge, the objection
was
is
no
that
people
her
for that.
reading to the
You don't
court
know.
what's in the report is cumulative, since we have the analysts here who will be testifying. to what the
Holy
report says
shit,
and what it
shut
means.
up.
So if I've got the report in there.
He's bitching that it's cumulative because she's reading what's in the report and not. But
You think he bad with this? I once watched him argue about attorney-client privilege for 3.5 hours.
yeah, because he was being paid the whole time.
Yeah, and Richland too. Especially Menendez brothers, they weren't cheap. The Menendez brothers, they had money, so he was getting a huge paycheck.
That's coming from someone that knows way more than I. That I'm sure it is. How is he doing this morning? Like, tell him I said hi. Well, he's probably listening, so don't pass along the message. Just hi, Jeff. How are you? All right. I understand some of the but some of this is just such trivial shit.
Yeah, I don't get what you mean by cumulative. I know what it means, but I'm like, what do you mean? Oh, they just been presented.
It seems so. I could see if there were like 3 reports that all said the same thing, and you submitted all 3 reports. That would, to me, or 2 reports that said the same thing. To me, that would be cumulative. But reading what's in this report is like, why waste the court's time? Why waste everybody's time? You're just making yourself look like a trivial asshole.
I'm like, this is something that should be objected to when a jury is present. He's a judge. He can separate. It doesn't really matter.
This right here is why people hate lawyers. Like from a layperson who's not a lawyer, who in general has an issue with people and their egos. Like, I hate egotistical people. And generally that's doctors, lawyers, fighter pilots, people with a high level degrees that think they are just better than you.
Yeah.
Because of the degree they have.
I don't know if he think like I'm the smartest defense attorney on this team because I've been a lawyer since 1978.
Yeah, people like that. But this is one of the reasons that people don't like like I will be that voice that says this is the reason people don't like lawyers. I will be that bitch. I will be that bitch that is like, this is the reason people don't like lawyers, because there's stereotypes for a reason. And this is the reason people don't like lawyers is trivial shit that they want to argue about.
Man,
I feel like this is why.
I miss Alan Jackson. I really do.
Follow the Karen Reed case, and I actually might, because one of the Karen Reed cases is a federal case, and I might follow one of those cases because there's so many cases civil cases that came out of the trial,
Oh yeah,
the criminal case, that I might follow some of them because they are fascinating.
I know all the
And
people they're doing the Turtle Boy stuff.
yeah, Turtle Boy, I don't have a problem with Turtle Boy as a person. He's just one of those people that it's just not my style of like the way I do things, but that's just not my style. It's fine. I don't have a problem with it. Like, you do you, boo.
From what I understand from Massachusetts, where they had that's the personality for that area. So
Yeah, and it's like, you know what? Whatever. Like, that's his prerogative. He gets to report and investigate however he damn well pleases. I just not my style of just not my style. But whatever. That's just why I'm me and he's him. So it's just one of those things. It's just we're different people. You know? It's just a thing. But this is why people, I'm convinced, don't like lawyers, because it's like you're arguing over the most trivial of crap at the wrong time.
when you see him cross-examine the witness, he probably gonna make you mad. This dude can create. I think the cross-examine the Menendez therapist for 4.5 hours.
But it's like, at what point does it cross the line from getting your objection on the record to just wasting everybody's time? Like, at what point? And I think this is the crossing the line. If it was multiple reports, I could see his issue with it being cumulative and crossing that Utah rule of evidence, whatever statute.
When there's a jury present, it's a judge. He can separate.
Well, there's still a Utah rule of evidence, and the statute that the judge read yesterday, or the rule that the judge read yesterday, I think it's 1102.
Yeah. That's hearsay.
But at the same time, all she is doing is reading something that is already, like, she's just reading something that's already introduced in evidence. Like, she's not adding to it, or it's just the trivial shit. And I understand sometimes that's what a lawyer's job is, to do the trivial shit. But like, at what point is it just wasting the court's time? And this is where I don't like this judge, because he lets them waste the court's time. And he needs to put his foot down and be like, stop wasting everybody's freaking time.
Like I said, Michael Burton, multi-attorney from California judges, at least the ones he practiced in, were not this lenient. So
you would think he would know better.
Judge Weisberger from Menendez was not. He was on borderline bias. He was nowhere near as lenient as this guy is on the bench here in Utah.
All right, we're gonna get this started.
Evidence, we don't need this witness's reading the report to the court. So it's a 403 cumulative objection.
Oh, 403.
Mr. McBride, do you wish to respond?
Not
My
11.
point is only to draw your attention, Your Honor, to the relevant results that will be discussed by the other expert.
It speaks for itself, but cumulative, that's not the right word to use for that.
That's what I'm saying. Like, it's not cumulative when she's just reading what's already there. If it was like another report, then I could see if like the FBI did a report and then the State Bureau of Investigation for Utah did another report, I could see that being cumulative. I could see him having a point. But this is bullshit. Like, this is just stupid.
As well as the results of the items we've discussed, the towel and the screwdriver. That's all.
All right, the court will overrule the objection and allow a brief overview of it, not going line by line, page by page. So if it
I
is
would have
brief,
just said
I'll allow that.
Thank you. So if you'll read item 7.1 to the word contributors at the top of that page, if you will.
Yes, male DNA was obtained from item 7 sub 1. Item 7 sub 1 was interpreted as originating from two individuals, one of whom is Twigs. The DNA results from item 7 sub 1 and are 1.7 octillion times more likely if Twigs and T. Robinson are contributors
Okay,
than if
so
Twigs
that's
and
what
an
the
unknown,
news.
unrelated person are contributors.
Oh yes, and Twigs is the roommate.
That's what the news clip was talking about, that his DNA was found. So now I know what that title. Okay.
Thank you. Let's skip down to item 8.1. Do you see that bolded and underlined
Yeah.
line there?
Yes,
And this is relating to swabs of the handle area of the screwdriver. Is that right?
yes.
Will you read those same two paragraphs there? Male DNA ending with contributors.
Male DNA was obtained from item 8 sub 1. Item 8 sub 1 was interpreted as originating from two individuals, one of whom is Twigs. The DNA results from item 8 sub 1 are 30 quintillion times more likely if Twigs and T. Robinson are contributors than if Twigs and an unknown, unrelated person are contributors.
Okay, thank you. A couple of foundational questions before we finish for now. First off, do you know who Twigs is?
Yes.
Who is Twigs?
Twigs is Lance Twigs. He was a roommate of Mr. Tyler Robinson.
And do you know if Lance Twigs' DNA was obtained for comparison in this test?
Yes, it was.
And how was that DNA obtained?
It was obtained by law enforcement officers.
And was that by a buccal swab?
Yes.
What is a buccal swab?
A buccal swab is basically like a Q-tip or a swab that we'll just place in someone's mouth and just scrub the inside of their mouth to obtain the cells.
And then that Q-tip is then packaged and sent to the lab for testing and comparison?
Yes.
And was the defendant, Tyler Robinson's DNA, also collected in the same manner?
Yes, it was.
Okay. Thank you. Nothing else.
Right. Mr. Burt, cross-examination.
Your Honor, I'd like to reserve the right to cross-examine after the witness completes their testimony after the following.
Oh,
Use the
would you mind grabbing the microphone? I just want to make sure what you say is on.
Use
Yes. Yes.
microphone. Even a 3-year-old knows how to use the microphone, sir. You are elderly. You should know how to do it.
And they had microphones in 1980s, 1990s courtrooms.
What is
So he
that?
knows what microphone is.
Mommy, it's a hand. It's a hand.
They had microphones in those California courtrooms.
Yeah.
Yeah, but maybe he's got some dementia.
Oh, wow.
I mean, it's very possible.
The record.
With the court's permission, I'd like to reserve the right to cross-examine on the area she testified about until she's completed her testimony.
Okay, I didn't. So, okay, I see what you're saying. Any input, Mr. McBride?
You use
Your
the
Honor, that's what we
microphone.
expected to happen. We discussed this beforehand. We stipulate.
All right, that's fine. And so, should I have the sergeant step down, or?
Yes.
Okay, Sergeant, if you'd like to step down, you're still under oath, and so please don't discuss your testimony with anyone. And is she being asked to exit the courtroom, or what's the request of the
Yes,
parties?
to exit the courtroom at this time.
All right, Agent, if you wouldn't mind exiting the courtroom, and then we'll come get you when we're ready for you. All right.
I think we're about to go to the defense witness now.
All right, Mr. Burt, turning to you.
Your Honor, out of order, the defense would be calling Amanda Baker.
All right, Ms. Baker.
We have it.
All right, Ms. Baker, if you wouldn't mind coming forward, right up here by the bailiff and being sworn in.
All right, let's see what this is about.
All right, Ms. Baker, water bottle for you if you'd like behind the monitor. And after you're seated, if you wouldn't mind just pulling that microphone close to you so it picks up your voice.
While we're doing that, good afternoon.
Good afternoon.
Tell us your name, please.
Hi, good afternoon. My name is Amanda Baker. My last name is spelled Bakker.
Ms. Baker, what do you do for a living?
I am a forensic examiner in the DNA case work unit of the FBI laboratory located in Quantico, Virginia.
And how long have you been a DNA analyst at that
I
location?
recognize
A little
her.
more than 10 years.
I recognize her from a case or something. I can't pinpoint where, but she testified in something else.
Interesting that they got a FBI DNA analyst to testify for the defense.
Yeah, they did say, the defense did say in the last hearing when they were ruling on the motions for hearsay and the contempt stuff, he did say they had like 3 experts, so they got at least 3 witnesses. 3.
Yeah, they had experts, but it's interesting that they got a government employee as an expert, someone
Yeah,
who
I'm not-
possibly worked on this DNA.
yeah, I'm kind of interested to see what she got now.
That's the interesting part. And did she come willingly, or was she subpoenaed?
And just in general, what are your duties?
My duties are to manage a case. When a case comes into the DNA casework unit, I will review any information associated with that case. I will review any evidence that is submitted for that case, determine which items of evidence need to be tested and which tests need to be performed. I will then create something called an exam plan. You can think of this like a to-do list to let the biologist know which items I need tested. Once that testing is complete, I will review all the data, draw conclusions in the form of a report, and then testify if needed.
Ms. Baker, in this case, were you requested by the state of Utah to do certain testing?
Yes, I was.
And when were you called upon to do that testing?
That was September of 2025.
And do you recall when the case first came into your lab?
I believe we received evidence the first time was September 11th of 2025.
And just in general, when the FBI, your unit, receives evidence for analysis, is it true that the turnaround time is about 200 days?
It depends. We've wavered between 90 days and over 200 days. I would say on average, it's somewhere between 180 and 200 days.
However, did this case come in on what's called a priority 1 level?
Yes, it did. And what that means is we worked 24 hours a day, 7 days a week until examinations were complete.
What's the point? Are they trying to say something about the fact that because Charlie Kirk had priority, that somehow I'm just confused. Where's he going with this?
DNA always, experts always fly in my head to begin with. This one, I really don't know. Coupled with that and the fact that I don't know where he's going, I have no idea.
But she said anywhere between 90 and 100 or 200 days. But the fact that he's bringing up the fact that it came in on priority 1 is somehow means my client is innocent. Like, those two things aren't correlated.
Yeah.
That to me is another one of those, here's a soundbite for the headlines, for the media.
Get the media thinking, get the potential jury pool thinking, like, ooh.
That this was, that Charlie Kirk had friends. Charlie Kirk did have friends in high places. Guess what? That's what happens when you make friends with someone you're campaigning for and they get elected. You have friends in high places.
That makes me wonder if the defense going to fall into some of these conspiracy theories. I hope not, but I can't sure at this
They're
point.
protecting his right to a speedy trial. No, well, here's the thing, Jeffrey. That doesn't make any freaking sense, because the only people who are interfering with their right or his right to a speedy trial is his own fucking defense. They wanted this hearing delayed even more than July.
Yeah, they tried to get
this delayed yet again. This was originally supposed to be in May. This generally happens 30 days after your initial appearance. Then it was originally scheduled for May. They got it delayed. They wanted it delayed again. So the only people interfering with his right to a speedy trial is his own fucking defense attorneys. Yeah, so that makes, I see where you're going with it, but the logic doesn't logic out, because they screwed the pooch on that one.
And is it true that you were conducting the analysis as the evidence was being inventoried?
That is true. Because of the high-profile nature of this case, an item of evidence would be submitted to the lab. It would be inventoried by our evidence management group and then sent to the various units for testing. For example, the DNA casework unit. We would begin testing as additional evidence was being delivered to the FBI lab.
Now, as a result of your analysis, do you produce case files?
Yes, I do.
And document your examination in other ways?
Yes.
Do you have your case file with you?
Yes, I do.
Okay. And in your case file, are there notes of conversations that you have with people that are relevant to your testing?
Yes, that's called our communication log.
Now, do you have your case file there in front of you?
Yes, I do.
I think the pages are numbered. So I'll ask you to go to page 22 of your case file notes.
Okay.
And if I could direct your attention to the bottom of that page, there is a communication log entry dated September 13th. Do you see what I'm referring to?
Yes, I do.
And would you read to the court what your entry is for that date?
Yes. This is my communication communication entry on September 13th, 2025.
I have been following
spoke
it.
with FBI
just
Special
not
Agent Folger and Utah SBI SA Dave Hull.
reading
Dave
it
technically
on my
reviewed
title.
results that Robinson was included as a possible contributor to the DNA from the towel and the screwdriver. We discussed the additional examinations conducted by DCU, and they both agreed that no additional immediate comparisons are needed at this time. All remaining comparisons will be in the laboratory report.
Is that an accurate reflection of what you told the agents at that time?
Yes, it is.
And you told them that, quote, Robinson was included as a possible contributor to the DNA from the towel and the screwdriver, correct?
Yes.
Was the language that you used in conformity with requirements that you have for reporting out test results?
Yes.
All right, I'd now like to direct your attention, if I could, to States Exhibit 31, which is in evidence, and I think it's our tab 2.
And Mr. Bird, are you requesting it to be displayed to just your screens or to all screens?
No, since it's in evidence, Your Honor, I'd like it displayed to the public.
Okay, let's go ahead and put it on the main monitor as well.
Hey, Coop.
Okay, could you go to page 6, please? And highlight the third paragraph.
Girl, you're killing my knee.
This is your report dated September 15, 2025, correct?
Yes, that is correct.
So this is 2 days after you had the conversation with the agents as to what your results were.
That is correct, yes.
And in your report that you wrote 2 days later, you included this language that's highlighted there, correct?
That is correct.
This report conforms to the Department of Justice uniform language for testimony and reports for forensic DNA examinations, correct?
Yes.
Okay. Now, I'd like you, if you could, to take a look at that standard that you referenced. And then I believe is that, and this will be just to the witness, not to the public.
Okay.
Calling up tab 7. Is this document?
Yes, I do.
And tell the court what this is.
This document is the approved standards for scientific testimony and reports for autosomal DNA testing.
And is this the document that you were referencing in your report?
One of them, yes.
And is it a true and accurate statement of what the policy of the FBI is in regard to reporting DNA in a case of this type?
Yes.
I move that document into evidence, Your Honor.
So is it just this page or all the pages? Because it says 1 of 6.
Yes, so this would be the entire document.
Mr. McBride?
Your Honor, I don't see the relevance of this document. I object on relevance grounds.
Mr. Bird?
Your Honor, the document
The
is
state
referenced
hitting
in the
them back with
report,
their own
and it-
objections.
But well, and that's true. But here's the thing. Well, what is the relevance of, unless you're going to try to say that they didn't use the appropriate wording, which means that you're going to try to toss the whole DNA report. I think that's where they're freaking going. I could be wrong, because I'm trying to think like a low life loser. And if I was a low life loser, that's what I would do. I'm not a low life loser. I know some. I don't have injections in my lips, so I can't truly act like one. But I know of a few. And I think that's one of the qualifications, is having lip injections. Really bad lip injections. But I'm thinking, if I were a low life loser, that's what I would do. But I don't think that's relevant.
Defines the parameters of what her opinion means. So I think it's very important for the court to understand the limitations of the opinions being expressed.
And just for my understanding, when you say in her report, are you referring to State's Exhibit 31?
That's correct.
All right, Mr. McBride, any further thoughts?
No, I'll submit it.
All right, so State's Exhibit, well, I'm sorry, how am I labeling this exhibit for the defense?
Your Honor, we have our exhibits organized by witness, and we
Okay.
would be submitting to the court electronic copies of these under named witnesses. So this would be Baker 7.
All right, Defense Exhibit Baker 7 is admitted into evidence, and as it relates to publication, what is your request, Mr. Burtz?
Your Honor, I would ask that this be published, since the report is published, and this is important to understanding the limitations of the report.
And so published in the courtroom and on the monitor for the media?
Yes,
Okay.
correct.
I'm
Any
surprised he want everything
thoughts,
published
Mr. McBride?
in the media.
No
I
objection.
will
All right,
say,
it will be admitted and published both in the courtroom and on the
he
monitor
used
for
to
the
be,
video.
so I
camera.
don't think he cares. He had cases.
Okay, so this document has various subjects, correct?
That is correct, yes.
And it, in the beginning, tells you how to frame your testimony in terms of inclusions or exclusions, mixtures, sex determination, et cetera.
Correct, yes.
And then there's a section called Statements Not Approved for FBI Autosomal DNA Testimony in Our Laboratory Reports.
That is correct, yes.
Okay, so if we could go to page 5 for that statement. Okay. Under the topic absolute identification, is it the policy of the FBI when you're reporting out results that an examiner may not state or imply that a match provides an absolute identification of the individual from whom the biological material originated?
That is correct.
And you were following that policy in this case when you told the investigators that this was a possible match, correct?
That is correct, yes.
You never said it was an absolute identification of Mr. Robinson, did you?
Correct, no, I did not.
Now, the second guidance under that policy is an examiner shall not use the expressions reasonable degree of scientific certainty, reasonable scientific certainty, or similar assertions of reasonable certainty in either reports or testimony unless required to do so by a judge or applicable law. You're not, in your report, did not use any language that suggested you were giving an opinion to a reasonable degree of scientific certainty.
That is correct, it was not.
Okay? And then the next one, not that one, one more down. Not going to talk about race, ethnicity. That doesn't apply to this case, right? But 5.4 says, an examiner may not state or imply that forensic autosomal DNA examinations have a zero error rate or are infallible.
That is correct.
And you followed that policy in this case, correct?
Yes, I did.
You're not in your report stating to the court that your testing has a zero error rate, correct?
Correct.
You're not saying that the test is infallible.
I am not, no.
What is the source of error rates in DNA testing?
I'm
You
sorry.
can take that down.
Can you clarify your question?
Holy shit! Holy shit! They're literally saying that the
Test
they're
that.
literally trying.
Test that.
Shh, stop, please. They're literally trying to say that the DNA is wrong.
When it refers to don't state that there is a zero error rate, what in general are the sources of error in DNA, in the kind of DNA testing that you do?
Human error could be an error.
Anything else?
Not that I can think of off the top of my head. One of the big things is potential human error. I guess you could also associate the DNA testing itself in how items are collected or how those items are tested.
Now, to your knowledge, that policy statement that we just read in Exhibit 7, Baker 7, was based on a more general Department of Justice policy, correct?
Correct, yes.
And that policy is called the Department of Justice Uniform Language for Testimony and Reports for Forensic Autosomal DNA Examinations using probabilistic genotyping systems, correct?
That is correct, yes.
And could you just,
For today's section, most media outlets got it set up for 3 p.m. Eastern, so I'm guessing they started late today.
Interesting.
Evening.
play
I don't
8 for us,
even-
please, to the witness?
Maybe they're almost finished, and that's why they started late.
Let me know when it's done. No, not on the big screen.
Okay, so not to go onto this main big
Correct,
screen.
this is
Thank
just
you.
for the witness. And you're familiar with that policy, correct?
Yes, I am.
Okay. And does it contain a statement that support for inclusion is an examiner's conclusion that there is evidentiary support for the inclusion of a known individual as a possible contributor to the DNA typing results obtained from an evidentiary sample?
I believe it does, yes.
And did you follow that procedure in this case?
Yes, I did.
All right. Does this same policy state at page 4, fourth down, one more. No, next one. An examiner, does a policy state, an examiner shall not assert that a likelihood ratio of any magnitude provides an absolute identification or source attribution of an individual to an evidentiary sample?
That is correct, yes. It does state that.
And you followed that procedure in this case, did you not?
Yes, I did.
You're not implying that those numbers that a previous witness quoted and are stated in your report provides an absolute identification of Mr. Robinson or Mr. Twiggs?
No, I'm not.
Okay. Thank you. You can take that down. Are you also familiar with a concept called formal activity level?
Yes, I am.
Tell the court what that is.
Formal activity level is determining an activity that causes DNA to be left behind on an object.
And does your laboratory have a policy about whether you can express opinions about formal activity level?
We do have a policy, and I cannot give an opinion as far as activity level goes.
And why is that?
That is because DNA can be left behind on an object for numerous different reasons. So just because DNA is on an item doesn't necessarily mean that an individual touched it or utilized that item. So because of that, we do not opine on what activity may have occurred.
And consistent with that policy, you cannot tell, if you interpret a piece of DNA as being present on an item, you can't tell when that DNA was deposited, correct?
I can't give an exact time, but there are some situations, if a piece of evidence has been buried for a long time or is in a river for a long time, it would be my expectation, based on my experience, that I probably won't get DNA off of an item that's been buried for 10 years, for example. However, I cannot give exact timing as to when DNA was deposited on an item.
And I was talking more about a situation where you actually find DNA on an object, be it a gun or anything else. You can't say when that DNA was deposited, correct?
Sure, that's correct.
And how long, in general, does DNA persist on an item? Once you've made contact, how does DNA get deposited on an item in general?
In general, DNA can be deposited a few different ways, via body fluids such as saliva or blood, or skin cells. So touching an item or wearing an item, DNA could be deposited. Once DNA is on an item, if it's subjected to ideal conditions, it's out of heat and high UV, it's not subjected to any kind of cleaning or chemicals, it can persist on an item rather indefinitely. It can degrade slowly over time, but we've certainly worked items of evidence that are 40 and 50 years old, and we've been able to recover DNA.
Now, could you explain to the court the concept of degradation of DNA samples, what that means and what it suggests with your testing?
Sure. So degradation of DNA is breaking up the DNA. So if you think of DNA like a long rope, it's essentially taking that rope and cutting it up into pieces. Seeing degradation in a sample could lend me to believe that there may be, that sample may have been subjected to cleaning or high heat an extended period of time. So I can't tell why an item is degraded, but looking at my data, I can tell if that sample is potentially degraded or broken down.
And two of the items that you examined were referred to as items 7 and 8, correct?
That is correct, yes.
One was a towel and one was a screwdriver.
That is correct, yes.
Were both those samples degraded to a certain extent?
May I refer to my
Certainly.
data? So item 8 was the screwdriver from the perch. I would say that there was some degradation. As I look at the DNA peaks or the DNA data, in an ideal world, if there's no degradation, I would expect all the peaks to be at the same height. Here I see a ski slope type effect, meaning that the data on the left is a little bit taller than the data on the right. As far as item 7, item 7 was the towel. There was a slight amount of degradation, but not as much as item 8.
Okay. And what is the effect of degradation on production of the allele? First of all, what's an allele?
An allele is an individual's DNA type. So we inherit half of our DNA from our mom and half of our DNA from our dad. We're looking at something called short tandem repeats, or STRs. These are small segments of DNA that repeat themselves over and over again. We all have those same sections of DNA, but what might differ amongst us is how many times it repeats, and that's actually what we inherit from our parents. So for example, at one particular location, my mom may give me 14 repeats and my dad may give me 15. So when I'm looking at the DNA types, I would say that I have two alleles at that location, a 14 and a 15. As far as degradation goes, it could cause some of those alleles to do something called drop out, meaning when I'm looking at the DNA chart or the DNA data, I do not see information, I do not obtain numbers at that particular section of DNA.
And is it true that in the testing that you were doing in this case, STR testing, what you were looking at is the length of the, what I'll call, have you ever heard the boxcar analogy?
I have, yes.
Tell the court what that is.
So the boxcar analogy is how many times that section of DNA repeats. So that section is essentially letters. So for example, A, C, T, G. So you may have A, C, T, G repeated 10 times or 12 times. Each of those sections of A, C, T, G would be considered one boxcar.
And so when you're looking for alleles, you're essentially counting the boxcars. Could be 7 boxcars, and that person would be a 7.
That is correct, yes.
And from the mom and from the dad, he may have inherited 10 boxcars.
That is correct, yes.
And so that person at that particular location would be a 710.
Yes.
And what you're doing in your testing is comparing those numbers to what you get from a known sample to see if they match.
Wouldn't that be your dad's a twin?
Okay.
Wouldn't that be like an uncle dad? Your uncle and your dad have the same DNA. That's because they're a twin. I mean, there's a social stop. There's a social media influence, not an influencer, but like a family that the kids call their uncle daddy because they have the same DNA because they're twins.
I want a
So-
baby. Stop.
You
I
stop.
want a baby.
No.
I want a
Are you supposed to touch mommy's mic?
baby. No.
Then stop.
Hey, baby. Hey,
That is correct, yes.
come back.
Now, is it true that what you mentioned the A, C, T, and G, correct?
Correct, yes.
Is it true that you are not measuring the sequence within the boxcars? You're just measuring the length of the boxcars?
That is correct. So the sequence would be equivalent to letters in a word. What I'm looking at is the number
I have
of
to go
words
do
versus
laundry.
the letters that make up that word.
And we'll talk about this a little later, but people can vary not only in the length of the boxcars, but in the sequence within the boxcars, right?
And that is correct, yes.
And what your testing looks at is just the length.
Correct, yes.
Okay. Now, and is it also true that you're looking across many different locations?
Yes. So at the FBI laboratory, we use a kit called Global Filer, and this is looking at 21 different locations on a human's DNA, in addition to 3 sex-determining locations. That lets me know if an individual is biologically a male or a female.
As between two individuals, 99% of their DNA is exactly the same, right?
That is correct, and that makes sense. We're all humans. We all have arms, legs, and a head. Less than 1% of our DNA is it differs amongst us, with the exception of identical twins.
But with within that 1%, you're looking at these length differences, correct?
Correct, yes.
And you're looking at what you called short tandem repeats.
Yes.
How many, you said you looked at 25 locations?
We're looking at 21 and 3 sex determining, so 24 total.
What are the sex determining, they're called the locus, correct?
Correct. So locus is that individual section of DNA.
All right, and they typically have names or numbers associated with them, correct?
Yes, I do.
So what are the sex determining loci?
So there is amylogenin, and that lets me know if an individual is male or female. And then there's 2 specific male sex-determining locations. One is Y-indel, and one is DYS 385. Those just let me know that those are specific to male individuals.
Okay, and then for the other locations you're looking at, those, you're just looking for 2 types at each location, correct?
Correct, yes.
Okay, now, for the samples that you looked at, the 7A and the 8A, did you get a full, what's called a full profile would be a profile where you have all 23 locations present?
That is correct. So a full profile means I have DNA at every single location. It is above our threshold, and I'm seeing 1 or 2 pieces of information at each location. For item 7, I did develop a full profile.
For item 8, you developed a full profile?
Item 8 was a partial profile, so I did not develop DNA at every single location.
Okay, so what that means in your comparisons is you have certain information in the question sample that for whatever reason doesn't appear, correct?
Correct, yes.
So you can't make a comparison at those locations?
That is correct.
All right. But what makes it not appear at certain locations?
So it could be that there's degradation. So those larger locations could be broken up so that it wasn't detected during the DNA process. It could be a low-level amount of cellular material to begin with. So if I only have a few cells, I may not have enough to detect at every single location.
Okay. And for the 8-1 sample, did you measure Mr. Robinson and Mr. Twiggs's DNA at the 23 locations?
For item 8, I did not have a full profile, so I did not have data at all 23 locations to compare to either Mr. Robinson or Mr. Twiggs.
Right, but you had full profiles for Mr. Twiggs and for Mr. Robinson, right?
For their known sample?
Yes.
Yes, so for their known sample, that was a sample that was taken directly from those individuals, and I did develop a full DNA profile.
Okay. And just to illustrate how this works, is one of the loci that you looked at called the DYS 391 loci?
Yes, it is.
And what type was Mr. Robinson at that loci?
At that location, Mr. Robinson was an 11.
And I think you said you inherit one from your mother and one from your father, but when you say he's an 11, technically he's what's called an 11-11, correct?
So for this, so DYS 391 is actually that male location, so he would not have, or anybody would not have inherited anything from their mother. So at this location, I would only expect to see one piece of information, and I did see an 11 here.
Okay. And for the D3S loci, what was his type?
His type was a 17.
Now, for that loci, you'd expect two types, correct?
That is correct.
And when you say he's a 17, do you mean he's actually a 17-17?
That is correct. He inherited 17 repeats of that location from mom and 17 from dad.
Other locations, for instance, the VWA, he's type 18-19, correct?
That is correct, yes.
So you're looking at those, and what the machine produces are peaks, correct?
Correct, yes. They're just spikes on a graph, similar to like spikes on a heart monitor.
And you said for 8A, you had certain locations where the test sample didn't have any results.
That is correct.
So at the TPOX location, Mr. Robinson is a type 8-9, correct?
That is correct.
Mr. Twiggs is a type 8-11,
That is correct.
but when you looked at the sample, 8A, it didn't have any of those types.
That is correct. So I could not compare at that location.
Now, are there certain rules for when you exclude someone? In other words, when you're comparing two samples, are there rules which say, here's where I would conclude that he could not possibly have contributed this sample?
Yes,
Your field has a lot of literature written about it, correct?
that is correct, yes.
And do you generally like to keep up with that literature?
I do, yes.
And across time, there have been several books, publications that attempt to educate you and courts and lawyers on the technical aspects of DNA testing.
Even the judge is looking like, is there a freaking point to this?
Maybe that's why he's like, I'm gonna schedule this tomorrow for the afternoon. I can't take 8-9 hours of this.
I feel like he's wasting the court's time, and even the judge is like, bro.
Now, I did see a lawyer who was saying that he does like recap the trials, and he's like, Nesta doing what she do best for the court.
I have to go help. I have to go help the little. So I'm
Okay.
gonna restart this and we'll
Yep.
talk.
Yep.
Right?
Correct, yes.
One of the books, early one, DNA Technology and Forensic Science by the National Research Council.
I'm familiar with that, yes.
That's an authoritative book that was really one of the first books on DNA testing,
Yes,
all right? And then by the same organization, National Research Council, the Evaluation of Forensic DNA Evidence,
correct, yes.
published in 1996. So you're familiar with that as well.
Yes, I am.
And then there's an author, I believe, who did his research work at the FBI named Dr. John Butler.
Yes, I'm familiar with him.
And you have studied his work both in your training and your continuing education.
That is correct, yes.
And he's got 3 current textbooks on the topic that we're talking about, right?
I'm not familiar with how many textbooks he has. I know at least the one.
Fundamentals of Forensic DNA Typing,
Yes,
familiar with that. Forensic DNA Typing Methodology,
yes, I'm familiar with that one as well.
and Forensic DNA Typing Interpretation.
Yes,
Everybody in your field relies on these publications and use them as teaching tools.
yes, I would agree with that.
And then in addition to those books, there have been studies that have been done on particular topics, correct?
Yes,
This case, we're dealing with mixtures, correct?
yes,
And mixtures present certain challenges that are not present when the samples are not mixed, correct?
not necessarily. So first, to define a mixture, that simply means DNA from more than one individual in a sample. So if I were to take a sip from a coffee cup and my husband were to also take a sip, if I were to swab that coffee cup, I would get a mixture, his DNA and my DNA together. As far as it being difficult, you can have some mixtures where there's one contributor that donates a lot of DNA and the second contributor donates a little bit. For DNA interpretation, that is not challenging for me. Where it can become challenging is if you have 4 or 5 individuals within that sample all donating roughly around the same amount, it may be challenging for me to determine if a person is included or not.
And would you also agree that that challenge exists in situations where you have what are called low quantities of DNA?
Again, that could be possible. So I could have low quantities of multiple individuals, which is simply just saying that I can't determine which piece of DNA goes with which individual. So that's possible.
What is drop-in?
Drop-in is where you have environmental DNA that's not inherent to that sample that's detected during our DNA process. DNA testing is very sensitive, so it could be that we have a peak that's detected, like I said, from the environment.
And what is drop-out?
Dropout is when you have an allele that is not detected or a piece of DNA information that is not detected. So in the DNA chart, there is no number associated with that particular location.
And degradation can cause dropout?
Yes.
So if you have a person at a particular location that is a type 1415, and because of degradation, that 15 drops out, what you're seeing on your...
If y'all don't recognize this shirt, this was the shirt Charlie Kirk was, well, the same type of shirt Charlie Kirk was wearing when he was shot.
Oh wow.
So, yeah, there's that. So, Mr. Squid owns it.
Wow.
Yeah.
Oh yeah. What I said earlier, that lawyer said he was like, eventually with all the pointless objection that the defense is lodging, this judge is most likely going to snap somewhere down the line.
Well, here's the thing. I feel like this is testimony designed to, or questioning designed to discount and basically say that the DNA testing is faulty.
Yeah.
Which is appropriate for trial.
Yeah.
I'm not sure it's appropriate for a preliminary hearing.
Yep.
I'm not. That's. I'm struggling with this because I just feel like this shit's not appropriate for the time and the place. This is, for all intensive purposes, a probable cause hearing to see if there's enough evidence to bound over for trial. And you are wasting so much time on DNA when there is video.
Yeah.
There is the weapon itself that belonged to his father. There is the fact that he turned himself in.
Yeah.
And I was talking to someone yesterday and they were like, I don't think he did it alone. And I don't think he did either. However, I think he has been, I don't think any of these school shooters or these these shooters who have been identified as trans after the information has come out about their identities, I don't think they are doing it alone. I don't think they are one and done. I think like this Discord group and this armed queers of Salt Lake City, I think there is like an underground or like a Discord network. Kind of like when I talked about Order of Nine Angels and how they communicated.
Oh yeah.
People are not one off because people were like, I don't think he's doing it. I don't think anybody, like a government, paid for him to do this. I don't think a government sanctioned this. Whether people are like, the Jews did it. No, y'all, let's think logically. I don't think he did it alone. I don't think he is just a one-off, like, lone wolf.
Yeah.
I think there is an underground network of like this group, Armed Queers of Salt Lake City. That's what they call themselves, YouTube. Do not come at me and do not limit my ad revenue. That is what they call themselves. But that group, I don't think they are alone. That group is a lot of people. And members of that group may have, like, you've seen TV shows, and I know this sounds stupid, but you've seen TV shows about the suburban mom and dad having like this, patriot group of like, we need to eliminate certain things. And,
A double knife.
yeah, well, they have money. I'm sure some people in that group have corporate jobs or jobs that make a lot of money, and they have access to things and they have resources. This is not just a 23-year-old who did shit, but yet he's not going to say that because he thinks he's in the right. So he's not going to give up names of anybody else because just like nobody else is either. But they are not lone people. Yeah. There is a network of people who think just the same way they do. They're just not advertising. It's Discord servers. It's what is that? Telegram chats. Like the same way Order of Nine Angels and the PDF rings stuff. They chat with each other. This is not so like for them to say that he's alone, he is not. But he is also intelligent and he's not going to give up the name of anybody else.
Yeah, like I say, you could make the argument that maybe he's not the mastermind, but
no, he is not the mastermind. I think it was a group of it's not, baby. I think it was just a group of people who think crazy, and he was like, "Yeah, I'm the one who, I think this is a good idea," and it just happened. Yeah. So I don't, yeah. Her answers are counteracting his leading questions, which are acting as though they're in trial. Yeah, it's just weird. Like, it's just weird. It's bizarre. Yeah, and Gail, I know our numbers are down because this is day 3 or the afternoon for me, day 3 of a hearing that is gaining is attention, but people are like, God, it's like a trial. It drones on.
Yeah, people, and there's multiple people covering. It's like 20 different people covering the preliminary here.
Either he's not alone or somehow got talked up into it. I think it's one of those things of like people talk a big game. It's like people on the internet, how they talk a big game and then all of a sudden somebody acts out and they're like, well, we didn't say anything. It's like, no, when you talk up doing things enough and when you have the rhetoric enough and someone finally does it, it's like, oh shit.
Yeah, you're going to be looked at.
You know what I mean? Like when you have politicians saying, if you see somebody, you get in their face. And then when somebody gets in their face, they're like, well, I never said any of that.
Yeah.
That's not what the footage says. Like, but, yeah, she's not happy because she's not on my lap. She wants to sit on my lap, but she's right here. She's literally arm's distance away. I'm just got to fold laundry. So the first U.S. trial use of DNA was in Orlando. Tommy Lee Andrews, serial rapist, in 1987.
Yep, that was interesting case. I know I've heard of that case. One of the Casey Anthony prosecutors prosecuted it.
Like, Flash fan, this is why I say you need to start a channel because like the history of all this stuff. Like you are a history buff in more ways than one. But like I might know the case because I watched some of Charlie's stuff. And I didn't watch everything Charlie did. Like
yeah, this case, you know more about this.
I know more about the people, but you know more about the lawyers. And other cases that these lawyers have done and other judges that these lawyers have been in front of. And I'm like, I believe you. Because you are a Flash fan and you know this shit and I don't. That's why I keep telling you, like, I know that I'm not trying to pressure you into starting a channel, but like, you need to know your worth because you talk about shit, and I'm like, I'll just let you talk because I have no idea. And this is where you contribute, and I'm like, that's what. Yep, we'll go with it because I know you're right, and I have no freaking idea. Especially with Michael Burt and the Menendez trial. I know about the Menendez brothers, but you actually watched that trial.
Yep.
And you actually know all about the appeal and the case getting thrown and going to a retrial. Like, you just know. And I'm
I
like,
had the transcripts for the retrial.
and I just, yeah. He keeps forgetting it's not a trial yet. Is he trying to test out different questions? You know, plausible theory. Plausible theory. I have absolutely no freaking idea.
Michael
Except
Burt
for
is one of those attorneys who is very not maybe meticulous is the right word. When he asks questions, he asks multiple questions to try to extract information. But I'm like, you're not in front of a jury.
see, and this is how I know I'm right. Is Heidel agrees with me. If Heidel agrees with me, I know I'm right. You know, because I know that I'm not always right, but if Heidel agrees with me, I know I'm right. It's a surefire thing if Heidel agrees with you that you're right. So
She is the help drunk.
Flash, the prosecutor in that case was Jeff Ashton. He went on to eventually become a judge. He went a bit crazy.
Yeah, contempt proceedings, yelling at attorneys.
Here's Flash. Here's where it gets interesting. Dad knows him very well.
Jeff Ashton? Wow. I apologize if I said anything that might have offended about Jeff Ashton.
Wait, this is the thing though. There's a difference between he says Jeff Grady knows him very well. He never said he liked him. There's a difference. So AJ in the chat. Jade, don't you already have a channel, Flash fan?
I have a Twitch. I need to figure out how to get my screen to keep sharing because streaming 4 to 6 hours isn't going to work if your screen stops.
You need a computer.
Yeah. I need to learn how to use the computer first.
That's it. Trial by error or trial by fire. Well, you got to get a computer in order to know how to use it. There's a chicken and an egg thing here. And I know it's semantics, but like, you know.
Oh, by the way, AJ, later on, I'm going to send you. I finished the timestamp for Wisconsin Day 2.
I mean, and I don't know the nature of the relationship between Volusia One and Jeff Ashton, but thinking like a lawyer would and breaking down the actual language used, there's a difference between knowing someone very well and actually getting along with them.
It was two parties. It was what's the lady's name? Jeff Ashton. The lead was Linda Drain Burdick.
Oh. We'll have to have a conversation on another at a later date. He said he will share some details off stream if you want to hear involved minor youngsters. Ooh, that's spicy. We'll have to save that for another day. Ooh. Jeffrey said they have little mini PCs that are under $200. They come with Windows 11 Pro. I mean, you could even Mr. Squid got a gaming PC from Walmart for like $250. So, you know. And hey, AJ, how are you? It's good to see you. All right, let's get back into this, Michael Burt. AJ, we're trying to get him to stream more. And I'm sorry I stole him for this week.
No, I've been able to make it. I've just been tired and shit. But
I've been tired too. I got up this morning and I'm like, I gotta go to the gym now, otherwise I'm not gonna go. And Christina was like, "Do you don't want to stay for 8:15 class?" And I'm like, I gotta look presentable at 9:30. And she's like, "The class gets out at 9:15." And I'm like, I have to go home, shower.
At
do
least maybe you
dishes.
at least maybe you get to take a little nap today since they in court at 3 p.m. Eastern, 1 p.m. Mountain Time. Not sure why they come into court so late, but maybe they're almost finished.
I don't know. Hopefully. I mean, there's a difference. Like, if this was a trial, it would be different. Like, I wouldn't mind this going on for multiple days. But this is a freaking preliminary hearing. This is for most people only a couple of hours.
Yeah. This is a very unique case, apparently.
And it's just like, you got new cookie sheets on the way? No, I am torn right now. So I am deciding oh Jesus. I am deciding whether I want to buy individual pieces or like a set, and what's more cost efficient and what I'm actually going to use. Because if I buy a set, am I going to actually use everything involved in the set, or should I just buy what I'm actually going to use? Like, this is how my brain works. I overanalyze shit. This is why I have a channel, because I overanalyze shit. It works on YouTube. It doesn't work in my kitchen. You know? Dad said his wife dumped his ass after she caught him when involved in an online escort service. Jeez.
Oh, wow.
Holy crap.
Well,
Oh my
okay.
God. All right, we're going to get back into this hearing, because that is a rabbit hole that will take an entirely different.
I knew Jeff Aston was controversial. I didn't know he was that controversial.
Ooh, this stream just took a turn, and back to the board.
I apologize, AJ, for I was like, you should cover the Casey Anthony case. I apologize now.
Back to this. Buy really good pieces you will use. Yeah, I'm wavering. So, when money burns holes in my pocket. When I buy stuff, I'm like, am I going to use it? I know I need stuff, but like, what am I going to use? What material should I buy? Like, is it going to last? Should I buy stuff that I'm going to have to buy again in 2 years? Or should I buy, that's how my brain works. Welcome to Squid World.
Chart is just the 14, right?
That is possible, yes.
And that presents a certain challenge, does it not? Because if the 15 is not there, you could misinterpret that as a type 1414, correct?
Not necessarily. So we have thresholds. We have something called the stochastic threshold. If that 14 is above that stochastic threshold, I'm confident, based on our validation, our testing, and my training, that the DNA type there is only a 14. If that 14 falls below that stochastic threshold, that could be indication that there is another peak. So when I'm comparing, if that 14 is below threshold and someone is a 14, 15, I will not automatically exclude them.
What is stochastic effects?
Stochastic
I'm
effect.
going to object at this point. I think we've gone beyond the scope of preliminary hearing. I think this is getting into 702 material that's not necessary for the probable cause determination.
All right.
I think
Mr. Burt?
I think it goes directly to the reliability of the testing results that the state introduced.
I have
I
no
think
idea
the court has
what
to
you're
understand
talking
the
about,
limitations and the potential sources of error in order to assess whether these results are reliable.
And
Not
in regards to
appropriate
this line
for a
of questioning,
preliminary
how far are you
hearing.
going to go on this line of questioning?
I have this one question, and then I'm moving on.
All right, Mr. McBride.
I'll hold them to that.
All right, well, Mr. Burt, so the objection is overruled. You may proceed with that question.
You can answer.
Could you repeat your question, please?
Tell the court about stochastic effects.
Stochastic effects, when you have low-level samples during the DNA copying process, based on how the DNA is copied, you could have alleles that are copied better than other alleles.
Okay. Now, on another topic, I mentioned studies before. One of the studies that you're familiar with is called the PCAS report. Are you familiar with that report?
Yes, I am.
And tell the court what that is.
PCAS stands for the President's Council of Advisors on Science and Technology. And this was a committee that was found, I believe, under the Obama administration that gave guidance on different areas of forensics.
Including how to deal with mixed samples and how to deal with samples that have low quantity of DNA.
I don't know that I would agree that it's how to deal with them. They gave some of their concerns on low-level samples and mixtures.
Right. And they also did a follow-up report to assess whether using the kind of...
Okay, I know this is semantics and me just being picky, but she could have said year or range of years. I don't know why her mentioning the administration that it started under was relevant.
That's for political reasons.
Yeah, I don't know why I don't know why that was relevant. I really don't know why that was relevant.
Software that you used in this case had been established as reliable, correct?
That is correct.
And what was the software that you used in this case to reach your statistical results?
The software is called StarMix, STRMIX.
We've heard that before.
And the PCAST report specifically addresses whether reliability has been established with respect to StarMix, correct?
I don't believe reliability came into question. I think PCAST thought that there needed to be additional testing as far as mixtures and low-level samples go.
Mixtures and low-level samples that had certain characteristics, right?
And that is correct, yes.
Including mixtures where what's called the minor contributor was in the sample below 20%.
That is correct. So the minor contributor would be an individual that donated less DNA to that sample. So PCAST called into question mixtures of 3 or more individuals with that minor or that low-level contributor making up 20% or less.
7 and 8 samples in this case were both mixtures, correct?
Yes, that is correct.
And did you determine what the proportion of mixture was between what I'll call the major contributor and the minor contributor?
So I did not calculate that personally. Part of the StarMix software, it does a couple different things. One, it takes a mixture and it uses math and biological modeling to try to break that mixture into its individual contributors. And then it also calculates a likelihood ratio, which is the statistic that I report. During that process, it does give an estimate of the breakdown of those potential contributors.
And what was, first of all, for this 7 sample, was the minor in there at less than 20%, according to StarMix?
Wait. So y'all bitched about the witness for the prosecution reading from the report, but she's reading from the report.
If I would have stayed, I would have made
Make that make sense.
I would have made the same objection if I would have stayed. Objection, Your Honor, cumulative.
And see, like, that's why shit doesn't make any sense to me, and like I had a problem with it because she's literally reading from her own report. They were literally reading from their report. Jesus, Pete, man. This is why people hate lawyers, because they're hypocritical. They do what they want when it serves them, and they argue against it when it doesn't serve their point, and it's just fucking annoying.
Yes, it was. For one of the runs, when I compared to Mr. Robinson conditioning on Mr. Twiggs, it was a 5% to 95%.
And how about for the other sample?
%, and the other was approximately 89%.
So below 20%, right?
Correct, yes.
And the concern expressed in this report, which was written by experts in your field, correct?
No, that is not correct. The PCAST report was written by individuals that were not practitioners or any type of laboratory personnel.
Right, but they list the experts who provided input into that report, do they not?
Yes, they did.
One of them was Bruce Bedoli, correct?
Correct, yes.
Who's Bruce Bedoli?
He is a DNA expert within the field.
Well, he was the head of your unit for a number of years before you came on board, wasn't he?
He was, yes.
And he's written extensively on forensic DNA testing, has he not?
He has, yes.
The report also lists Eric Gilkerson, correct?
That name does not, I do not recall that name.
Forensic examiner for the Federal Bureau of Investigation Laboratory.
I don't recognize that name.
How about Bruce McVicker, forensic examiner, Federal Bureau of
Objection,
Investigation?
Your Honor. I'm going to renew my objection. I think this is beyond the scope of determining probable cause. The standards that apply here are that the court weighs the evidence in the light most favorable to the state and avoids credibility and balancing the evidence of the stage. I think we're far into 702 territory at this point.
Mr. Burton.
I'm not sure I understand the
kinda do have
objection.
to talk to him, 'cause he
I'm
will
not sure
go
I
into it.
understand the
702 deals
objection.
with reliability of evidence. That's what the court is here to determine. So again, it's directly
You
relevant
kind of
to
have to stop him
reliability.
because he will go for
This
3 hours
report
straight. You better.
criticizes for the specific sample she's using here, the reliability of this testing. And her response was, oh, but they weren't experts. But the report indicates that there were experts who were consulted on this report. So I think it is relevant, and I think it goes to the issue of reliability, and it's the only
I
question
want
I
him to
have
say
on this area
sustain
as
so
well.
bad, but he probably not going to sustain it.
Anything further, Mr. McBride, or do you wish to respond to that?
Just that 702 deals with admissibility. It does discuss reliability, but it's directly related to admissibility of the testimony at trial under the Utah Constitution. And under the robust case law in this area, the court does not weigh the evidence, draws the inferences in the light most favorable to the state. And I think we're beyond that point now, getting into the admissibility questions.
All right. Anything further, Mr. Burt?
No, Your Honor.
All right. Well, as this is the last question, I'm going to overrule the objection, but as a reminder to all parties that this is a probable cause standard, and as it relates to, well, I will just leave it at that.
Are you familiar with that analyst?
No, I'm not.
Okay. Just to close the loop on the PCAST report, what they said in the report was that published evidence supports the foundational validity of probabilistic genotyping with some programs of DNA mixtures of 3 individuals in which the minor contributor constitutes at least 20% of the intact DNA in the mixture, and in which the DNA amount exceeds the minimum required level for the method. Isn't that what they concluded?
That sounds accurate, yes.
And do you know why the level 20% raises reliability issues?
I do not know.
Okay. But you do know that in this case, both your samples had minor contributors below 20%.
That is true, but in this case, it was also only a mixture of 2 individuals.
All right. Now, that's the next thing I was going to ask you about, which is what is NOC?
NOC stands for number of contributors.
And when you use this program, this genotyping program, Star Mix, who decides what the number of contributors is?
That's my determination based on my experience and training, looking at the data. That's something I input into StarMix.
Right. And that's a complex determination, is it not?
Not necessarily.
But it can be in some cases, correct?
It could be, if there's mixtures of a lot of individuals and a lot of the peak heights, the size of the spikes are relatively the same, it could cause some trouble for me as an examiner.
All right. One of the groups that studies your field is the National Institute of Standards and Technology, correct?
That is correct, yes.
They're in the Department of Commerce,
I believe so, yes.
federal agency.
Yes.
And they published a report in 2024 called Forensic DNA Interpretation and Human Factors, Improving Practice Through a Systems Approach. You're familiar with that publication, right?
I am, yes.
And was that a publication written by scientists?
I don't recall exactly who the authors of that publication were.
Okay. Just to make sure. That it's a long report, right?
Yes, it is.
And you've read it.
I've read highlights of it.
Is it true that one of the things that they say in that report is they have a section on the complexity of number of contributor estimations?
Objection.
Are you,
Same objection, Your Honor. This is beyond the scope of a preliminary hearing. Again, we're talking about expert reports. We're talking about scientific studies. These materials are all fine to consider at a 702.
The judge's gonna need to start sustaining
at this
some of
stage,
these.
where again the light
Yeah,
of the evidence
he
is
is,
the
but
state.
he's not
This is
going
unlawful
to.
Divorce determination, therefore irrelevant to this proceeding.
Thank you, Mr. McBride. Mr. Burt.
Your Honor, I think the report that the state put into evidence, as clarified by this witness, indicates that she reached the conclusion that
He's gotta
Mr.
let the
Robinson and
defense
Mr.
run the
Twiggs were,
courtroom, or
quote,
the lawyers
possible
run the courtroom.
contributors to these two samples.
He's too
And
nice.
so the one thing the court has to weigh is what is the weight of that opinion, given the science or lack thereof? And one of the important issues here is how she derived these statistical numbers. And as an offer of proof, I'll indicate to the court that the numbers derived from this software program, and that software program is dependent in large part on how many contributors the analyst puts into the input of the software. And the numbers can change if the number of contributors is changed. And in this case, as I'll show through the examination, this examiner originally thought there were 3 contributors. And I will show to the court why she changed her analysis, and will indicate through this publication that there has been criticism of the way in which she determined the number of contributors. So I think it's important for the court to assess whether you've got accurate numbers in front of you. The state put in these astronomical numbers and are asking the court to give weight to them. And I'm asking the court to consider how those numbers were arrived at and whether there are reliability issues with regard to those numbers.
So the concern that I have is, I turn to State v. Ramirez in 2012, UT 59, paragraph 10. It states, furthermore, the magistrate's role does not encompass an assessment of whether such inference is more plausible than an alternative that cuts in favor of the defense. That is a matter of fact-finding, which is left for the jury at trial. And so when I'm staying in my role as a magistrate, I hear what you're saying, but my concern is based off case law that dictates what I as a magistrate should be doing. If I want to stay in that lane, my fear is, as we go down further down this path, which again, is not precluding if this were to proceed, if there were a bind over, if there was a trial, that certainly that could be determined. But at this point, at this stage, how do you weigh this issue as I'm weighing State v. Ramirez in deciding whether we're going past the probable cause stage?
Sure, and I think the answer to that is we have to take into account the ruling that you made in this case, which is the law of this case, which is when we objected to the hearsay aspect of these DNA reports and other reports, you ruled that you are the ultimate determiner of the reliability of the hearsay evidence being admitted. And you will recall that our argument was the statute was unconstitutional because it was dictating that you find certain evidence to be reliable without considering whether it was reliable. And your ruling, as I understood it, was no, you retain the ultimate determination of whether the evidence is reliable. And that's not a credibility issue. It's, is this reliable hearsay that the state is offering? And so issues that go to whether these numbers that the state is putting in front of you are reliable, I think go directly to the substance of your ruling, which is that your role here is to determine reliability of evidence.
Stop being
And
stupid.
I'm familiar with a case that the court cites, but I think that has more to do with weighing evidence and making credibility assessments, whereas I'm focused on what the court ruled, which is we have to look at reliability here, and that's my job as a magistrate.
Mr. McBride, any final thoughts?
Yes, under Rule 1102B4, this the Exhibit 31 is considered reliable hearsay. In addition, credibility determinations are not proper for the court to make here for the whole reason that, you know, studies supporting the science, studies opposing the science, testimony from this expert or that expert about what is reliable, what is not, what's more reliable, what's less reliable, factors that affect all those determinations. Those are all very, very complex decisions. There will be probably multiple day hearings dealing with that, and a probable cause determination is just not the place to conduct that kind of thorough, in-depth, and searching analysis. Rather, the case law, the Constitution of Utah that says the only purpose of a preliminary hearing is determining probable cause, the case law, the rules that all say the court does not weigh the evidence at this stage, but leaves that for a finder of fact, the jury, in the end. That all supports cutting this line of questioning off at this point rather than going on for into greater depth, Your Honor.
All right. Well, based off what's been presented before me, I'm going to sustain in part and deny in part the objection made. I'm going to allow this question to be asked, and so that is denying, but sustain in the sense that this would be the last question, and if Mr. Burt would chooses to, may go on to a different subject or a different line of questioning.
Sure.
Stop being so polite, Judge.
Did that
Tell him to
nice
shut the
report
hell up.
conclude that it remains unclear if visual inspection renders consistent number of contributor estimations across analysts over time?
Can you repeat that?
Yeah. Did the report, the NIST report that you referenced, conclude that it remains unclear if visual inspection renders consistent?
Yep.
She read the, like, what does that say? What does that say? Yep. Flash fan?
Again.
Yeah.
It's a
I cook
bird.
almost exclusively on cast iron. Main thing is their heat control. Medium is your new high flame setting. Yeah.
Yeah.
I mean,
Yeah.
I cook a lot on the Blackstone, and that's for all intents and purposes cast iron. But good morning, Roy. Hugs to you and the better half. I hope everything is going as well as can be expected. Hugs to you. Let me know if you need anything, even if it's a shoulder to cry on virtually. We are all here for you. Yeah, but she says everything I do. Tell Mr. Burt to move on. Avery. Angel, tell Mr. Burt to move on.
Again.
Yep.
Number of contributor estimations across analysts over time.
I think that goes to the DNA evidence. Again, we never truly know the number of contributors in a forensic sample. So, like I mentioned before, you could have DNA mixtures that are made up of 2, 3, 4 individuals. I have training, I have experience, I followed standard operating procedures. So I'm making the best determination based on the evidence, the DNA evidence that I have.
The perfect judge for this case. He's nice, but he's also firm. Judge Crane from Sarah Boone.
Yes. Polite, has a sense of humor, but puts his foot down and says, no more of this crap.
Yeah, he would be a perfect balance between the niceness, politeness, and firmness.
Just more of Mr. Burt going into things that are more appropriate for trial and beyond the scope of a preliminary hearing. And the judge being too nice and not putting his foot up Mr. Burt's butt. Yeah. I mean, like, it's easier today as they delivered the Hoyer lift yesterday. Yeah, that should be much easier for her. For you, too. Hoyer is always a helpful thing.
As far as number of contributors goes.
Now, if I could, I'd like to return to your case notes. And could you display for the witness page 365 of tab number 4? And while he's doing that, by the way, it's true that if you change the number of contributors, you're going to get different numbers from the software program.
It depends. So actually, each time you run the software, you will get a different number based on the math that the software system does. But there are studies and validations that show we don't expect that math to be greatly different, usually by a factor of 10. Changing the number of contributors depends. If you have a major contributor, someone who's made up most of that DNA profile, if I originally interpret something as 3, calculate a statistic, if that major contributor is the individual that I'm comparing to, if I change the number of contributors to 2, based on the studies and based on my own experience, it doesn't change the likelihood ratio of that major contributor by much.
But it does change it, correct?
Yes.
And you just said, I think, that even when you put in the same parameters, you don't get the same answer if you run it through STR mix more than once, right?
That is correct. Based on how StarMix utilizes math and distributions, you will never get the same answer twice, but it will be no more than a magnitude of 10.
So that test is not reproducible in the sense that you can run it a sample or your assumptions in there 10 times, you could get 10 different answers.
That is true. Again, all within the first time I run StarMix, I'm not going to get a likelihood ratio of 10, and the second time get 10 quadrillion. I might get 10 quadrillion the first time, 2 quadrillion the second time, but even if I run it 10 times, I'm still going to get around the same likelihood ratio value.
Now, could you look at tab number 4, your case notes at page 365, if you could bring that up for the witness? I think you need to scroll up one page. Can you identify this page from your notes?
Yes, I can. These were notes that my technical reviewer made, and my technical reviewer, they will review all of my DNA evidence. They will draw their own conclusions as far as number of contributors and comparisons, then compare back to my conclusions.
All right, so this is regarding the 7 sample, correct?
That is correct. That is one of the samples.
And your original assessment was that there were 3 contributors to the sample, right?
That is correct, yes.
And that conclusion was reviewed by a reviewer, correct?
Correct, yes.
She read the same electropherograms or the name for the output of this technology you use, correct?
She utilized the same electropherogram, which is the chart that the DNA is on.
And does this page in front of you, is that an accurate representation of your case file?
Yes, it is.
Moving to evidence page 365, and that would be Baker 4.
Mr. McBride?
I'll object on relevance grounds.
All right, did you want to respond, Mr. Burt?
Your Honor, it's relevant because the witness originally determined that there were 3 contributors, and I'd like her to explain to the court how she reached that conclusion, because I think it does go to the reliability of her testing here.
All right, so as it relates to Baker 4, and this is her personal notes from Ms. Baker as it relates to what I'm assuming is State's Exhibit 31, these notes were prepared as part of the report in State's Exhibit 31. I would find that it is
Your Honor.
relevant
Your
and
Honor.
that it is admitted into evidence as regards to publication. What is the request?
Your
Mr.
Honor,
Byrd?
if I may clarify, I think the testimony was that this was not her notes, that these
I-
were the notes of her technical reviewer, is what I heard.
Please correct me if I'm.
So question, quick question. If those were not her notes and the notes of her technical reviewer, wouldn't that be hearsay? Just a question. Putting it out there. Just putting it out there.
He gonna still end up allowing it.
Just
Put
putting it out there.
put it.
Sorry. Oh my goodness. I'm just putting it out there into the universe because because technically that wasn't her work.
I will
So,
say this
I'm just-
case that made me want to do
Dun,
research
dun,
about the
dun.
law.
And I'm over here. Dun dun dun.
This case that made me want to do research on the law, and no other case that made me want to do that yet. But this one is-
Objection. The question used logic, and that we don't acknowledge. Oh my goodness. It's just. I feel like he's objecting, not so much that he's launching real objections. It's just because
they are
Bert
just-
is taking forever and he's got to shut him up or get him to
Yeah,
move on.
like I said, you don't stop him. He could go for 3 to 4 hours straight.
Yeah. And I think the judge is like, I'm sick of you. I'm sick of you. And Gail, I got a bakeware set and some extra cookie sheets and a dry or a cooling rack.
Ooh, cookie, speed of cookies. I think I got some cookies around here somewhere.
Well, baking sheets.
Uh,
Sheets. But they're 3 different sizes, so they should, But then, like the baking sheet, the baking set has a round.
I know you talked about a while back, but the Blackstone thing you was talking about earlier, is that similar to like a George Foreman?
It's an outdoor cast iron skillet.
Okay, so kind of like a miniature grill.
Yeah, it's got ours is 2 burners. But it's basically 2 burner cast iron skillet outside.
Okay.
Just heard that from both sides. I want to make
I
sure. I want to make sure. Are these Ms. Baker's notes?
Could I clarify that?
Absolutely.
Ms. Baker, these are notes in your case file, correct?
These are notes in my case file, but they're not my notes.
And the way your lab works, you're not the one that does all the different steps in the testing process, correct?
That is correct.
Other analysts have input that then all goes into the case file, which you have access to and rely upon in rendering your opinions.
That is correct, yes.
All right.
And this particular page is a note written by your peer reviewer that you relied upon.
Correct. After I made my interpretations and drew conclusions, my technical reviewer then reviews the data and draws their own conclusions. So this was created after I had already drew my own conclusions.
All right. I'm just trying to put it together.
The witness
here.
is like, next question, please. I've got this. I feel like they didn't bring her on as a witness to boost up their side. They brought her on as a witness to tear down her work.
Yeah, she probably won't be a trial witness, or if she testifies, she might be called by the state.
Yeah, I think they brought up a witness, her as a witness to like tear apart her work, and she's like,
And some attorneys
I got
do that.
this,
So you
bitches.
even though you still got to do direct examination, some attorneys do that. They did that in the Karen Reed case at trials. They would call like state witnesses and try to destroy their credibility while also like giving direct examination. It got kind of funny because the judge like, remember, this is direct examination, not cross examination.
yeah, Judge Auntie Bev. Bevy cannoli. Or cannoli. But though, yeah, that's a whole can of worm.
I think she
And
retired.
so the question I'm trying to get to, counsel, is was this particular, I recognize it as it being prepared by someone else, but as it relates to State's Exhibit 31, was this relied upon in order for State's Exhibit 31 to be put together as the report? Because I'm trying to determine relevancy as it relates to that, and that's a crucial point I don't have the answer to just yet.
Okay. Let me lay a more adequate foundation. The case file notes are assessed by you at every step of the analysis, correct?
Not necessarily at every step. Before I issue a report, before I write a report, I review all of the case notes. So that will be any communication log entries, any documentation from the laboratory, the biologists that perform the DNA testing. I will review all of that, write a report, and then give that to a technical reviewer. They will draw their own conclusions to determine if they agree with me. If they do, they will sign off, and then my report and my case file will go for an administrative review to make sure that the laboratory number is correct on all the pages. That if there's any crossouts, there's dates and initials and so forth. Those two reviews have to be done before I can actually make it a final report and case file that gets submitted and sent to the field.
And in this case, correct me if I'm wrong, but the sequence was you originally determined in sample 7, that there were 3 contributors. That conclusion got reviewed. Then you ran some further testing, and then you change your conclusion, correct?
And that is correct, yes.
Right. And before you change your conclusion, you of course go back and look at what the reviewer said about her review.
We would have a discussion. If I say number of contributors was 3, here she notated that it was 2. We had that discussion. She agreed with 3. So for that step of that process, because again, we're piecemealing this. Typically in a normal case, we will work all of the evidence. I will write a report. For this situation, I had DNA evidence coming to me throughout the day, throughout the night. So I had reviewers at different steps, which is not usual for a case. Usually I have one reviewer. So in this case, at that particular time, I had a reviewer. And then when I was submitted additional known samples and used those for comparisons, then I did have additional conclusions and additional reviewers.
But you certainly took into account this notation on this page before you change your conclusion, correct?
I don't know that I would agree that I took into account. We had already had that conversation. And again, once I received additional known samples and additional information from the field, I then did amend my conclusion.
And these notes are kept in the ordinary course of your business,
Yes,
and they're part of the case file that you rely upon in reaching your conclusions.
they are kept with the case file after I draw my conclusions.
So, Your Honor, I think there's a foundation for this. The state has offered all kinds of hearsay here, and certainly this is, there's no question about the reliability of the entries.
All right. Anything further from the parties before I weigh in on, well, make my ruling on Baker 4?
No.
The court finds that it is relevant, and as it relates to State's Exhibit 31 and Baker 4 is admitted into evidence. In regards to publication, Mr. Burt, what is your request?
That it be published
All right, in the courtroom.
in both the courtroom and to the cameras.
All right. Any,
He wants it
10
published to
minutes
the
to rule.
He wants it published to the cameras so that it can be published to the media because we all know what the headline will be. Third person's DNA.
It's kind of like they want to object to the media, but then when it kind of like they don't want it. It kind of like they want both. Like we don't want the media.
They
but then we-
only want stories that bolster their side. They
Yeah.
only want stories that make them look good. They only want stories that they only want cameras when they look positive. They don't want cameras, they don't want media, they don't want headlines when it's not good for their client. They are hypocrites. They don't want the truth. They just want narratives. In order to have the truth, you need the positives and the negatives. Not everything is going to be one way. Sometimes things are going to go your way and sometimes they're not. And
You
that's
win
how
some,
you get
you lose
the
some.
truth.
Yeah.
It's
You win some,
just-
you lose some. You're not gonna win them all. If you won them all, this wouldn't be a fair legal system.
Even Sarah Boone, even Judge Kranick agreed with Sarah Boone sometimes.
Yep.
So that right
She had
there
me
is how
won
you
more
know.
pro se. She had me won more pro se fights than I thought she would win.
Oh my God. If Sarah Boone wins some, the woman who recorded her crime,
Both her and Lori Vallow won more than I thought they would win.
this is a courtroom. There's no room for the truth in there. Yeah, but this is why I dislike them, because they only want shit, and they are saying specific things, and they are using specific words that I recognize as headline making, headline grabbing, controversial. They are not saying
Yep,
things for the
if the
purposes
cameras
of.
were excluded once this case was over, you can just imagine now. Defense giving interview. You know, Mr. Robinson didn't get a fair trial. The state and the judge was corrupt against them.
But if cameras are in there and we see everything, they don't want the state's exhibits published because it doesn't look good for their client.
Yeah.
But they want their exhibits published because it looks good for their client.
If I'm the
That
state,
is some
I'd be
fucked up bullshit right there.
If I was the state, I'd be so petty. I'd be like, well, Your Honor, we're going to object to publication to the courtroom.
Trigger words. Yes. Trigger words. Like, yeah. It's like a dog whistle.
Objection, Mr. McBride. All right, go ahead and publish that to all screens and may be captured by the media.
So these notations at the top there, 7-1 male, discuss 3 NOC and okay with 3. Could you translate that for us, what that means?
Sure. So when my technical reviewer took a look at the DNA evidence, she determined that male DNA was present, and she concluded that she would have called it a number of contributor of 2. She compared it to my conclusions. I said number of contributor 3, so we had a discussion as to why she thought it was 2, why I thought it was 3, and she said she agreed with me calling it 3 based on our discussion.
Okay, so was that an extended discussion you had with her, or just?
Oh, no, this was a quick discussion, and this is not unusual. We have discussions like this during the technical process quite often.
And the stamp on the bottom, approved by Tara Benson, is that the reviewer?
Yes, it is.
Talking about? All right, thank you. Now, I want to ask you to look at page 128 of that same exhibit. No. Is this an electropharogram that is a part of your case file?
Yes, it is.
And is this an accurate representation of what's depicted on this page?
I'm sorry, there's nothing on the screen. Am I?
128. 4, page 128.
Oh, I thought I already admitted Baker 4. Is this a different? The previous one was Baker 4, as I understood it.
Yeah, Baker 4, page 365.
Oh, okay. So
And so this is Baker 4, page 128.
Right, so the previous admitted exhibit is Baker 4, 365. The current proposed one is Baker 4, 128.
That's correct.
All right, Mr. McBride.
If I can have just a minute to update my notes on those page numbers.
All right. 365 was the previous one, unless I heard it wrong.
Yes, that's right.
All right, and the current one is 128.
First, I'll note this is the first I'm seeing these as exhibits. Of course, I have this file, but I was unaware that we were going to be these are going to be offered as exhibits. So I'm looking to find them in my file as we go. Second, again, I'm going to object on relevance grounds to the probable cause determination. We're going through the finite details of the analysis here, and once again, I think these are appropriate questions to raise in a 702 hearing. But with the standards that apply at the preliminary hearing that I've already discussed, I think we're beyond the scope of probable cause determination as we dive into this evidence.
All right, Mr. Burt.
Your Honor, I think this exhibit is particularly important because the court does not yet have in front of it what an electropharogram is and how it's interpreted. And this particular page will illustrate to the court how the analysts interpreted the peaks on this electropharogram to reach the conclusions that you reached, that there were 3 and not 2 contributors. And I think it will assist the court in determining exactly how this comparison process works and what the output looks like, so the court can see exactly how the interpretations are being made.
And is this the notes that were relied upon? So I'm viewing today's Exhibit 31 as a summary, and this more of showing the work of how the summary was reached. Am I misunderstanding how this fits in?
This fits into how the analyst originally was of the opinion that there are 3 people here and not 2. and she will go on to explain how she changed the interpretation from 3 to 2. And the point of this is to illustrate to the court that this is a subjective process to a certain extent, and that people can read these things in different ways. And so I think it will help the court understand exactly what's being compared here. You've got peaks on a line, she will say, and just to let the court know in response to Mr. McBride's statement that he was unaware that this is going to be an issue, he and I met with this analyst before the preliminary hearing. The analyst pointed this page out to us as being illustrative of why she originally concluded that there were 3 contributors. So this is not something that's being sprung on the state. He was a part of that conversation, and this particular page was identified by the analyst, not by me. So it is important to understand why we went from 3 to 2 and what impact that has on the numbers that the state is offering.
All right. Anything further?
No.
All right. Under Utah Rule of Evidence 1102,
No.
I
B4,
don't.
it says scientific laboratory of forensic.
I don't disagree with that argument, and that's kind of pathetic. I think it's the wrong time for the argument, but the actual argument itself, I don't disagree with.
Yeah.
I think it's not an appropriate time for the argument. I think that's more of a trial argument than a probable cause hearing argument. But
Yeah, 'cause that's like discovery issues.
yeah, but the actual crux of the argument, I
Yeah.
don't disagree with. Like, I don't know if that makes any sense. Like, you shush.
Reports and records. I find that this is admissible and is admitted into evidence as Baker 4, page 128, and is a request to publish this document.
Okay, you can.
Was that a yes? Oh, okay.
Yes.
All right. So published, I'm assuming to that
Yes,
screen as well. All right.
correct.
Maybe published. Counsel, just as a reminder, as this is a probable cause, I understand and I appreciate you give me a pointer of where it's going. But
I
just as a
have
reminder,
to get
as
a
probable
little more
cause,
water. I'll be right back.
Yeah.
It is admitted, and you may discuss it, but I definitely want to keep this within the track of probable cause.
Understood.
All right.
Thank
you,
you.
Mr. Burt.
Okay. Is it true what I just told the court, that you pointed this particular page out as illustrating why you originally thought we had 3 contributors?
Yes, that is true.
So explain to the court, is this an electropherogram?
Yes, this is an electropherogram. Each of those rectangles at the top, for example, D2S441, that is that small segment of DNA that I referred to earlier. And each of those peaks has a corresponding number that is the allele, so that corresponds to the number of repeats that an individual inherited.
And this is what you ultimately, after you get this electropherogram not through running it through SDR-Mix. There's a different device that you use to produce these electropherograms, right?
Correct, yes. During the DNA process, this is the last step of that process. So what it's doing is DNA is found in cells of our body. We're taking those cells, we're breaking them open with chemicals to release the DNA from those cells. We're making photocopies of those pieces of DNA so that we can essentially see them. And then the last step is to separate those pieces by size, and the ultimate output is this electropherogram.
Okay. And is it true that you set the parameters for what the machine will pop up in terms of numbering the alleles?
Personally, I do not set that up. That was done during our validation of the chemicals and the software and the instrument that we utilize. But there are parameters so that the output of the DNA lets me know, for example, the different types of alleles, but that's not a parameter I set.
I want to make sure you answered that. You set, or your lab sets, what the machine does in terms of labeling particular alleles, correct?
Yes, that's part of the whole process and the validation, yes.
So you could tell the machine, give me all the peaks at whatever level and label them as whatever the alleles are.
I see. So yes, so during our validation, we determine our thresholds, our analytical threshold and that stochastic threshold that I mentioned before. The analytical threshold is a threshold that was determined during validation that we input into the software that I utilize that says, for example, our analytical threshold is 150. Any peak that is 150 or greater, the software system will give me that allele call or that number for that peak. Any peak that's below that 150, the software system will not give me an allele call for it.
Even though it might be a true allele.
Correct, yes.
So you could say, and you refer to a measurement, you refer to that as RFUs, right?
Yes, that is the unit.
What does that mean?
It stands for relative fluorescent unit.
So in your lab, you tell the machine only label peaks that come above 150 RFU.
The software that utilizes the information from the machine, yes.
However, it's true, is it not, that in determining the number of contributors, you look below that 150 RFU level.
And that is true, yes.
All right, now on this is only showing 4 different locations, right?
Correct, yes.
And you see a number of peaks at each one of these locations. Some of them are labeled, some of them are not.
Correct, yes.
So tell us how you originally looked at this and said there's not 2 contributors, there's 3.
Sure. So first what I do is I count how many labels that I see, so how many of those little squares under each of those locations. So for example, at D2S441, there are 3 squares. Knowing that one piece of information comes from mom and one comes from dad, if it's a single source profile from one individual, I expect to see no more than 2 squares. Because I see 3, that gives me an indication that there's at least 2 individuals. Same thing for the next D19S433. And as well as FGA. There were 3 peaks that were called. So I knew this had to be at least 2 individuals. Then what I do is I take a look at the peaks that are not called and determine could there potentially be a third person included. So for example, at D2, the location farthest to the left, I'm asking myself that 12 in that bottom box, is it the same contributor as, for example, the 22 under FGA all the way to the right? Because I see peaks that are not labeled, it could be that the 12 belongs to one individual and those 2 peaks that are not called belong to a second or third individual. And that at FGA, I could be seeing the 22 from that third person, but that second person has dropped out. Because I'm able to use information below the threshold and I see peaks, that gives me an indication that I can increase my number of contributors to 3, which I did in this case.
Okay, and when did you reach that conclusion, time-wise?
If I recall, it was somewhere around September 12th.
And when did you change your conclusion?
That I would have to
Forgot to
refer.
close the top. Brought a load of laundry over here. Knocked the water bottle over. Just sat on its side for like 20 seconds and just, well, it was probably more like 10, but just spilled all onto the floor. So good thing I just brought towels in here because I now have to rewash one of my
I
towels.
changed my conclusion on September 13th of 2025.
And explain to the court why you changed your conclusion?
I was submitted an elimination sample from Mr. Twiggs, and an elimination sample is a sample in which it's from a known individual, and then there's an expectation that the individual's DNA might be present. In receiving that sample and talking to the investigators, it was decided that Mr. Twiggs should be used as an elimination. When I compared him to this sample, all of the DNA, unlike that major contributor, matched to Mr. Twiggs. So because of that, I determined that there's actually only 2 individuals because those small peaks, there was nothing left for a third individual to be compared to.
You use a phrase elimination sample. That's typically used, is it not, in a situation where you're testing a sample that has more than one contributor?
Not necessarily.
Okay, so what did I miss? Because luckily the water went all on the floor. It spilled literally this way and went all on the floor right here. However, is he arguing that there's 3, that there's 2, or that the DNA was so messed up that they couldn't tell if there was 3 or 2, so it should be thrown out?
I think from what I can tell from this, like, he lost me a while back, but I think he's trying to say that Twitch is maybe the culprit. Maybe that's what they're going to argue, a third-party defense, because they bring up his DNA was there.
But like the
Or
3
their
versus
DNA
2,
was
I'm like,
there.
what does it matter? Like, unless you were going to say that there's a third party, but now she's saying I changed it to 2. Are you trying to argue that it was on? Like, what's the ultimate point of this? That you're spent all this time arguing.
It seems like this would be like a suppression issue to suppress some of these samples or chain of custody challenges instead of preliminary hearing testimony.
It's like, what's your freaking point? Do you have one? Is there a? It seemed like his point was changing mid testimony, which doesn't make any sense to me. And this is why I say people hate lawyers, because your shit doesn't make any sense. You take a half an hour, 45 minutes, however long this has gone on, to talk about something that we could have gotten done in like 15 minutes.
Yeah, this witness could have been gone already.
Ugh. I swear they get paid by the word.
Yeah, this preliminary hearing is lasting all week because you imagine this is the first defense witness. They got 2 more, and then the state, I believe, got 2, at least 3 more, not counting the recorded statement. So, yeah, this is lasting all week.
An elimination is just simply an individual that we're expecting their DNA to be there. So for example, if we have a stolen vehicle, I will request an elimination sample from the known driver of the vehicle so I can subtract out their DNA to see what I have left over. It doesn't necessarily have to be more than one individual. There certainly has been times where I only detect that known expected individual.
And you said you had a conversation with the investigators as to whether Twig should be included as, or you talked to them about whether you should get elimination samples?
I talked to them with regards to if I should utilize Mr. Twiggs as an elimination versus comparing him and offering a statistic.
Okay, but in your report, you concluded, did you not, that one of the contributors to both samples was Twiggs?
That is correct, yes.
Right. You didn't just assume that, you reached the determination that he was the source of both those samples, one of the sources, right?
I don't want to use the word source, but knowing that there was an expectation that his DNA could be present, when I compared him to that DNA sample, I did see his DNA types present. So using the word assumed, that's verbiage that we use when we calculate our statistical calculation. I'm letting the software know, I know this individual is there. I'm assuming that they're there. Based on my comparisons, I did see evidence that that person was there.
But I guess what I'm confused about is we talked before about how your language should never imply an absolute identification. But in the body of your report, you say that one of the contributors is Twiggs. You don't say he's a possible contributor like you do for Mr. Robinson. You say he is a contributor, do you not?
I do, and with elimination samples, that's slightly different. So for example, let's say I have a sexual assault case and I have a vaginal swab from a female. She has a consensual partner. I can request an
To my YouTube overlords, she said it, not me.
elimination sample from that consensual partner. If I see that they're present, I can say they're present and say the DNA foreign to that victim and that consensual partner is one person, for example. So it's different than comparing a known individual. If they're an elimination sample, I can say that I expect their DNA to be there, and based on my interpretation and reviewing that data, they are present.
And based either on your conversations with the agents or other people, why did you think that Twiggs was someone whose DNA you would expect in those 2 samples?
So from what I recall, in speaking with the investigators, Mr. Twiggs was a roommate of Mr. Robinson, and it was thought that those items came from potentially Mr. Robinson's home. And I don't recall exactly if it was a situation where a particular towel was known to have been in that house. I don't remember that exactly, but in talking to the investigators, based on their investigation, it was important to assume potentially Mr. Twiggs was present.
Right. Did any investigator ever tell you that the towel did not come from Mr. Robinson's home, but was found in a bush out at the university?
I was aware of that, yes.
So you knew that that towel was not found in a place where you would expect Mr. Twiggs's DNA to be present?
He's
And
using
yeah, this is essentially a cross-examination at this point.
essentially, but it's one of the things of like, yes, the towel was found in a bush. Take that one how you will. Pun or no pun. However, that towel originated from somewhere. He didn't pull the towel out of his ass. Potentially. Prison wallet notwithstanding. The towel had to originate from somewhere, like a house. Set example. Towel. So, y'all, he's arguing something that, like, it sounds good in theory, but he's not thinking through the context of, like, the towel had to come from somewhere. The towel had to come from somewhere. Yes, it was found in the bushes, but it had to come from somewhere, like a fucking house.
Be like, yes.
And if he owned the towel, it most likely came from his house.
I'd be
And
like,
if it
yes.
came from his house, they're most likely is a chance that his roommate might have done the laundry and put it away, which means his roommate's DNA might be on it.
Do you understand? I'd be like, yes, counsel. That's how the laws of the world work. Typically, a towel, clothes, or anything has to come from a general location, and
I would expect much more DNA and other matter if it was from the prison wallet. Touché. But it was like he makes a good argument on the surface. But as Mo says, once you logic it out, and this is, see, if I was, the prosecutor and I were to cross-examine this witness, I would be like, yes, the towel was found in a bush, but where did the towel originate from?
and maybe he might still do it.
Who was the owner of the towel, and where was the towel? Like, was it part of a set? And were other matching towels found at his home? Perhaps, like, maybe this was the towel used, but this was another towel that was found in his house, and oh my God, they look alike. So one would assume that
Be like, oh my God, really? I didn't know people had more than one towel.
sometimes you just how has he survived as a lawyer for 30 years?
More than 30 years.
How?
78. That's what, 40 some odd years.
Is he senile? Or does he not understand technology? Or does he not understand the internet?
That could be the
Or does
internet.
he not understand sheet sets because he is a man, and towel sets because he is a man,
Maybe all of
and
the
he
above.
doesn't strike me as a gay man.
No, he married, I believe.
Like,
white
don't get me
man.
wrong, but
He wasn't an attorney.
I know the man who I know who knows more about towel sets and sheet sets and everything than I do. His husband knows a lot about it too. Good. I'm just saying. But if I ask Mr. Squid where we got the towels from, he gonna be like, that's a you thing. Exactly. Yeah. I mean, my dad knows a lot about towel sets, but that's because he's single. And he kind of had to do that shit on his own. If he's married, he don't know shit about towel sets. And this is glaringly obvious right about now.
He's been an attorney for 49 or 48.
And it doesn't show. Or maybe you can be very, very intelligent and be so smart in the terms of sciences and things that you lose the basic common sense of like the towels. The towel was found in a bush. But where'd the towel originate from? Did the bush make the towel? Was the towel stored in the bush? Or was the towel like brought from a home? Sometimes shit just is so glaringly obvious to me. And I don't know if other people are like this, or this is just how my weird brain works after 3 concussions and 2 skull fractures. Just glaringly obvious that some shit just adds up to me and just doesn't make sense to people who are supposed to be smarter than me. All right,
He was admitted to the bar on November 29th, 1978.
Yeah, my parents didn't even know each other in 1978. Just saying. They didn't. It's a fact. It's a fact. In fact, my dad was, I think my mom was still in high school in 1978.
My mom was just about to graduate high school and just about to start working.
All right, let's see where he's going with this.
That is correct. It was found outside of a home, but again, based on speaking with the investigators, they had information to suspect that that towel came from Mr. Robinson's home, and I should utilize Mr. Twiggs as an elimination.
All right. And again, you didn't assume that you actually
Holy
concluded
shit,
it
didn't I
based
just
on
say
match,
that?
right?
All right. And he sounded surprised. This is the only reason why I wish we could see their faces is I would have really liked to see their face because did you see the judge? Did you look at the judge?
To suspect that that towel came from Mr. Robinson's home, and I should utilize Mr. Twiggs as an elimination.
All right. And again, you didn't assume that you actually concluded it based on the match, right?
Based on
The judge just looks over at like, you got anything for that? Like, you just got
Like, you sure about that? You sure you want to keep going down this road?
like the judge is very stoic, but at the same time, the way he just how quickly he moves.
His expression, he literally changes for about 2 seconds, and then he's back to him.
Yeah, it's like a micro expression. It's there, but how quickly he turned from the witness to Mr. Burt was like it bears repeating.
that that towel came from Mr. Robinson's home, and I should utilize Mr.
Like, look
Twiggs.
how fast he looks up from his notes. Oh, like that towel came from Mr. Robinson's home. You don't say. Yeah, there we go. Confirmation. I was still in high school in 1978. We met around 1981. Yep. Like, just the way he flips around and looks at Bert, how quickly, and then he's back to stoic.
As an elimination.
All right. And again, you didn't assume that you actually concluded it based on the match, right?
Based on reviewing Mr. Twiggs' DNA profile to what I developed from these items, I used him as an elimination sample.
Now, you did various STR mix, what I'll call runs, correct?
That is correct, yes.
And the way this works is you input the number of contributors. You determine that. And then they also have something called HD and HP, right?
Correct, yes.
Teleport what that is.
So those are different propositions. So in calculating the likelihood ratio compares the probabilities of seeing a DNA profile given one of two different scenarios or explanations or hypotheses. One is that a particular person of interest is a contributor, and the other is that an unknown, unrelated individual is a contributor. So depending on the question being asked is how I set up star mix, number of contributors. For example, if I'm utilizing someone as a known elimination sample, I will apply their DNA profile both to the HP and HD.
And the theory of this, HP is the prosecution hypothesis, right?
Correct, yes.
And HD is the defense hypothesis.
Correct, yes.
So, and these are things you plug in based on your understanding of what the prosecution and the defense are contending.
This is exactly. Thank you once again for putting words into my mouth that I in better ways than I can form sentences, because sometimes like I just look at people and all I can think of is you're a fucking idiot, and the actual like reasoning as to why doesn't exactly come out eloquently.
Yeah,
An example of an attorney with no scientific education in DNA trying to impeach a DNA expert. That's why good attorneys counter DNA experts with other DNA experts if they can. Silly man.
yeah, and his high profile case back in the 90s didn't involve DNA. Menendez's case didn't involve DNA.
And this is why I like my chat and I like doing this live, is because if I were to record myself reacting to this, all I would come up with is what the fuck, what the fuck, what the fuck, what the fuck.
Yeah,
It wouldn't actually be like coherent sentences, and looking at what chat says, being like, yes, those are the words that I'm trying to say that my brain cannot, when all I can look at someone and go, you're stupid. Is all the only like logical, coherent words that are coming to my brain right now is you're stupid.
We
And
need
it's like, no, I
prosecutors.
know there's more in my brain that I want to say. However, my brain injury, the fact that I've had 3 concussions, 2 major head injuries, and 1 brain surgery, the countdown, 3, 2, 1, my brain doesn't exactly function like other people's when it comes to forming coherent sentences. And I have a thought. I just have some expressive aphasia sometimes, and I know what I want to say. The words just do not form.
We need Prosecutor Squid going up against Michael Burt.
Oh my God, I could not. This is probably one of the many reasons why it's a good thing I didn't go to law school. Because I can keep my composure when I was with patients, because I was able to match their energy. When they were a dickhead to me, I would match that. I'd be like, you want to be a dick? We'll go. Like, well, then get up. Like, I don't care. Well, get up. My knee hurts. Well, then you shouldn't have sat like that. Like, you match the energy that you're given. I can do that with a patient, especially when I have access to all their medical stuff. And I know that me pushing them and pushing back on their pushback towards me pushing back on their personality is going to be safe.
Yeah, court is a little different because judges don't like that.
That I can't do that with witnesses, and it becomes argumentative, and I can do that with patients because it works. You match their energy. If they are super sweet to you, you be super sweet to them. If they are a little more bullheaded and need that, tough energy, I guess that's why I liked working with difficult personalities, because I am a difficult personality. I mean, that's why Mr. Squid and I work so well together, is because no other bitch could handle him, because he is a difficult personality.
Hello.
Yes. What is this? A center for ants?
Hi.
Kind of for kids who can't read and want to learn other stuff?
Mommy,
Yeah.
in the hat.
Yes. You have quiet
Mama,
thoughts and loud thoughts, and the loud thoughts win. It is Nana. Yes.
Correct, yes.
So how do you plug in the HD in a case where you don't yet have
You
a
want to
defense?
say hi? Okay. Say what you want to say.
Hello.
To who? Who do you want to say hello to?
Hello, Naha.
There we go.
Postulating what their theory is.
So HD, or the defense hypothesis, is simply the DNA profile, the probability of the DNA profile, given that it's another unknown, unrelated person to the prosecution's potential person of interest.
Mr. Burt, I don't want to interrupt your line of questions, but we've been going for just shy of 2 hours. Would right now be a good time
It'd
to
be a
take
great time, Your Honor.
All right,
Thank
let's
you.
take a 15-minute break. Let's see. We'll come back at 3:50. Court is in a brief recess.
Line.
Mid-afternoon.
Mid-afternoon break. We have about an hour and 20 minutes of this.
And what additional statistics needed to be run at that time?
So at that time, I believe I ran statistics with just twigs comparing that individual to the sample.
Hello, guys.
If I may refer, I think that was the only additional.
Hey, what's that? Hey, it touches hello. Mommy, the hello.
Judge had a tinkle.
Mommy,
Yes, after discussion with my reviewer, it was determined that
I love time travel thanks to fast forward. This is petty playback. Like we skip the bullshit. Like let's be honest here. Nana texts you. Yes.
Yeah, Nana text.
That's why you don't string this stuff now. You can't string this case now. This is gonna be brutal trying to pick the real.
This is going to be a woo-hoo.
I was also going to calculate a statistic or compare Twiggs by himself, comparing him to the evidence, and having that run in my case file.
Okay. And could you go to tab 38, page 39?
Oh,
Yeah, it should not be on the screen.
let's pull it down from the screen. Thank you. So
Okay.
just to the monitors of the attorneys and the witness, Mr. Burt?
Just for the witness, Your Honor.
Okay, just for the witness.
39.
Damn.
And this is it. Yeah, page 39. Or that was produced as a result of your inquiry that involved a comparison of the sample to Mr. Twiggs alone.
Yes, it is.
And is that a 6-page report?
Yes, it is.
And is it a true and accurate copy of the SDR mix report for that particular sample?
It's Star Mix. Get it right.
Mommy, stop. Stop this.
I know. I'm sorry, Angel.
Yes, it is.
I'm getting an attitude.
Move that
but
indefinite,
he's
Your Honor. This would
huge.
be Baker 38, page 39
She
through
doesn't like when I raise my voice. She
44.
gets mad at me.
Baker 38, page
Right.
39 through
I'm seeking admission as well as publication to the audience and the camera.
Oh,
I just
audience
want to make
and
sure
the
I have the
camera.
label correct.
Yes.
Baker 38, pages 39 through 44. Did I hear that correctly?
That's correct, Your Honor.
All right. To the state?
Yes, Your Honor, I object on grounds of relevance to the probable cause determination.
Okay.
All right. And
Probable
Mr.
cause.
Hurt, would you like to respond?
Not probable
Submitted.
cause. Semantics. Hi, Gail.
So I'm not exactly sure what this is in order to
Sure.
determine
Let
how
me-
it fits into the probable cause analysis.
Sure.
So a little bit more information, because as of right now, I don't have enough to admit it.
Understood,
It
and I apologize
doesn't.
to the court. So the report that was admitted into evidence has the conclusion in it that both samples were contributed, that Mr. Twiggs was a contributor to both samples. And this is the report that the analyst ran in order to make that determination, I believe.
You believe, which means you don't
All
even
right,
fucking know.
and did these reports, were these made prior to
Wait,
Stacy's
am I
Exhibit
wrong?
31 being prepared? All
Yes,
Please correct me
That's
if I'm
correct.
wrong.
right.
I'm-
I will admit, so
Yeah, not language is important.
Baker 38, pages 39 through 44 is admitted and may be published. Again, as a reminder, for all attorneys, this is a probable cause standard, so if all parties can just keep that in mind as we're
You need to
moving
be
forward on this.
firmer with
Sure.
that,
Thank
Judge
you.
Grimes. You gotta be
All
firm.
parties, aka the defense, I'm looking at you, but I have to tell everybody so that you don't bitch that I'm calling you out. It's like toddlers when you have to yell at everybody so that one person doesn't go, well, she's singling me out.
Yeah, it's like the kid yell at the kid. They be like, "You yelled at me."
No, I yelled at everybody, so shut up. like at the gym when there's all the kids there and one of the moms yells at her kids, I'm like, include my kid in there too, because I'm guarantee you she was either instigating or part of the problem too. Like, don't exclude her from the stuff. Like, you know, this, you know,
you
don't.
different with them. Not a parent by don't tell me how to parent my kid. Don't yell at my kid.
No, I'm like, if y'all are yelling at your kids, I'm guarantee you that mine was involved in that somewhere along the line and probably instigating the whole thing. So if you're gonna yell at your kids and my kid is in the mix, please include my child in the discipline as well. I am not one of those people who are like, don't yell at my kid. No, if my kid's being a little shit, yell at my kid too, please.
Oh wow.
Don't lay a hand on my kid. If you're gonna like spank your kids, please don't spank my kid. Leave that part to me. But like, if you're gonna yell at your kids, you're gonna yell, you know, include mine in the you know.
Don't me.
Oh no, you're fine. Ma, I gotta fold laundry.
Stop me.
thank you.
And so it may be published to all screens.
Yeah, it's page 39.
I gotta run and put laundry in the dryer and switch over another load. Be back.
Yep.
So is this the report that you referenced in your notes that you needed to run the sample through StarMix?
Yes,
Now, at the top, this is the StarMix unit dated September 15th, and it relates to item 7-1, correct?
that is correct, yes.
All right. And then down below that, the kit used, if you could go to the summary of the input. You tell the software program, assume there are two contributors, right?
Correct, yes.
You input sample 7A,
Correct, yes.
and when you input it, it's just the raw data, right?
Correct, just the numbers from the graph.
The numbers, and then known contributors under HP, the prosecution hypothesis,
Correct, yes.
right? And you put in sample 61, right?
Yes,
That's Twiggs's known sample.
correct, yes.
And then the known contributors under the defense hypothesis, you left that blank.
Correct.
Is that because you didn't know what the defense hypothesis was?
No, again, the defense hypothesis for this situation, if I'm comparing someone, is an unknown, unrelated individual, and that is taken into account during the calculation.
Okay, and then you input that data, and what you get out from that is a likelihood ratio, right?
Correct, yes.
So let's go to page 2 of that report. And is this a summary of the results from that test on the 15th in terms of a likelihood ratio?
Yes, it is.
What is a likelihood ratio? What does that mean?
A likelihood ratio is a statistic that calculates the probability of seeing a DNA profile given one of two different hypotheses. One is that a particular person of interest is a contributor, and the other is that an unknown, unrelated individual is a contributor. The probability with the higher number gets the support, and the magnitude of the support is determined by the ratio of those two numbers.
That's pretty technical stuff, but the bottom line is that the software computes the numbers, and then you look at those numbers and determine whether it has any significance, right?
I don't know that I would say if it has significance. I report the value that's calculated.
Right. And why is one column, these columns relate to different, what are called population databases, right?
That is correct, yes.
The one on the far left, BAH, is an FBI population database on Bahamians,
And African Americans, yes.
African Americans. Another one for Caucasians,
Correct, yes.
SEH is Southeast Hispanics,
Correct.
and then
Don't tell me
Southwest
you won't blame
Hispanics.
African
Correct.
Americans.
That's all I have on that. I'm just trying to explain the chart.
All right, well, there's an objection. Let's pause and turning to Mr. McBride.
Sure.
Your Honor, at this point, I'm going to object on, again, grounds of relevance to the probable cause hearing. State v. Drosbeck, State v. Merrill, State v. Ramirez that the court has cited, all hold that the court should bind the defendant over for trial unless the evidence is wholly lacking and incapable of reasonable inference to prove some issue which supports the prosecution's claim. I don't know that any of this analysis goes to whether or not the expert's testimony and her report is wholly lacking and incapable of reasonable inference to prove her result in this case. We're far beyond this. We're hours into this examination. This feels like a 702 hearing to me. I think we're far beyond a probable cause hearing, Your Honor. I would ask the court to sustain the objection, not allow questioning on this or any other matter that does not deal with the issue of probable cause.
Thank you, Mr. McBride. Mr. Burtz.
Your Honor, the state offered this report on a very technical, complex, scientific area of inquiry. And they offered to the court a conclusion in that report that Mr. Robinson and Mr. Twiggs were contributors to two samples that were found at the crime scene. They obviously think that's relevant to the probable cause inquiry, or they wouldn't have offered the report in the first place. So having done that, I think the defense is entitled to inquire whether those conclusions are reliable, because that, again, is the court's ultimate determination here, reliability of this evidence. And the court can decide it's not relevant, it's not reliable, therefore I'm not going to rely on that in determining probable cause. And that, or the court could say it is reliable and it bolsters up other evidence that the court is going to hear from. So the particular report in front of us goes directly to the issue of whether the expert correctly concluded that Twiggs not was a possible contributor, but was a contributor. And the state's theory here apparently is that both Mr. Robinson and Mr. Twiggs are somehow connected to this crime scene. So I think when the court sees what the numbers were generated and how that compares to her own standards for assessment, the court will see that the conclusion is not justified that she reached.
All right. Well, I understand what both parties are saying, and at a probable cause hearing, the issue is whether we walk 1 mile or 100 miles down the path, and so I want to keep it limited to 1 mile and as opposed to 100 miles, because that would exceed the probable cause standard for a preliminary hearing for what is before me. And so, Mr. Burt, as it relates to the objection, I'm going to sustain it in part. If you want to briefly address this and move on, you certainly may choose to do so, but as it relates to where we're at, my hope is we can keep this very brief as
Yes, I
opposed to
can do
going
that.
through all this, so we can move on to whatever else you would like to present.
Thank you. I will do that, Your Honor. In the interest of doing that, could you bring up on the same screen part of her report, People's Exhibit 31?
And let's take that off.
I'm going to need that up there because I need to do
Oh,
it.
so is it part of the same? Because it was on that screen. I want to make sure that what you're calling up on the screen right now, is it part of this that was already admitted or something else?
It's part of this, which has already been admitted, compared to Plaintiff's Exhibit 31, which
I
has
see,
also
okay.
been admitted.
Okay,
So
thank
they're
you. I
both-
just wanted to clarify.
Sure.
All right, so and do you want that published on this all
Yes.
screens? All right, let's go ahead and do so.
And the chart I would like you to bring up from that report is on page 5. Yeah, just highlight that. Thank you. So what we've blown up there is from your report, Plaintiff's 31. And you provided this chart in the report, correct?
That is correct, yes.
Explain to the court how this works, what this chart is supposed to represent.
Sure. So this is our verbal scale. In addition to the numerical likelihood ratio value that I provide, I also give a qualitative or a verbal equivalent to that numerical value. That gives some kind of context to what that likelihood ratio means.
Okay, and on the left, explain what the greater than 1 million, less than 1 in 100 means. What does that scale relate to?
Sure. So that scale is the numerical value of the likelihood ratio. So if I have a likelihood ratio that's greater than or equal to 1 million, I designate that as very strong support for inclusion. The next example, 10,000 to less than 1 million, I would say that's very strong support for inclusion, and so forth.
So you need to reach a likelihood ratio of 2 in order to get even limited support for an inclusion, correct?
Correct, yes.
Okay, if you could not reduce that and go to page 2 of the report on the left. So from this chart, when you ran Mr. Twiggs against a sample, what was the likelihood ratio that you determined?
I believe this chart is not the comparison to Mr. Twiggs.
That's not in the report?
The chart at the bottom of the screen is not my comparison to Mr. Twiggs.
Let's verify that if we could. Take that down.
You put Jesus Pete. I'm sorry. The fuck? Like. Oh my god. Sorry.
Repost.
Just do it. You just screwed it up. You tried to prove a point and
Page 39,
you made yourself look dumb.
what was the likelihood ratio that you calculated based on this chart?
The likelihood ratio was 1.
1.
Yes,
So that doesn't rise to the level of even limited inclusion, correct?
correct. It would fall under an uninformative.
Uninformative, and yet you concluded that despite this STR mix reading with a likelihood ratio of 1, that Mr. Twiggs was a contributor to both item 7 and item 8, correct?
I did. So actually, I didn't utilize this calculation to determine that Mr. Twiggs was a possible contributor, or that I could use him as an assumed contributor.
They're really
I
focusing on
visually
that
looked at the
remain.
DNA sample, and the DNA, unlike that major
Yeah, I'm
contributor,
thinking they're
he
gonna
also
argue
had
for
those
the
peaks.
third
So that was
cohort.
one proposition or one hypothesis
That's it,
that I
what they
determined that
put,
he was
more
an assumed contributor. There are multiple different ways. We don't have a threshold. I don't have to see 2, 4, 8 peaks to determine I think an individual is present. Given that the field submitted him as an elimination, I assumed he was a contributor. When I compared him to that data, I did see his DNA present. So when I calculated the statistic for Mr. Robinson, I used Mr. Twiggs as an elimination.
See if I understand that.
You
The
don't.
STR mix that you
It's over your
relied
head.
on to include Mr. You relied on the STR mix to include Mr. Robinson as a possible contributor, correct?
Correct, yes.
But when you ran Mr. Twiggs' sample through STR mix, the result you got was that he was not a contributor, correct? Or that it was not even of limited value in including him.
Based on the STAR mix run, it was uninformative, but I did use my own knowledge and training to determine that I was going to utilize him as an assumed contributor.
Okay. Your own knowledge and training. Is there some standard that you use for deciding when not to rely on the STAR mix results and when to sort of disregard it and rely on your training and experience?
I can't say that I disregarded it. When I'm comparing someone, that's my first determination. Do I think this person is potentially included or excluded? If I determine that I think they're included, I will run STAR mix to give weight to that inclusion. Elimination samples are different. If I'm told that an individual is submitted as an elimination sample, I can assume they're there. Visually, I'm able to look at the DNA evidence and determine, yes, I think there's enough evidence there to assume that individual, which is what I did here.
Okay. At D16, Mr. Twiggs was a 912, right? According to your electropherograms?
That is correct, yes. Mr. Twiggs was a 912 at D16.
912. And did you find 912 at that location in the 8-1 sample?
I'm sorry, sample 8 or sample 7?
Sample 8.
The only piece of information I had for sample 8 at item D16 was a 12.
And you said Twiggs at that was a 912, right?
Correct, yes.
But at that location, the evidence sample was not a 912, but a 12.
That was the only piece of information that was recovered at that location.
Let me ask you about,
He He's saying these numbers. He has no idea what these numbers mean.
I guess he's just throwing numbers out there at this point.
He has absolutely no friggin' idea what these numbers mean. And I don't either. And I don't either. I gotta get her a rag. Hold on.
Interpretation rules for excluding someone. Is this an accurate statement? This is from Butler's textbook. In forensic DNA analysis, if any STR locus fails to match when comparing the genotypes between two or more samples, then the comparison of profiles between the question and the reference sample is usually declared a non-match, regardless of how many other loci match.
I would agree with that if it's a single source sample. So single source, again, meaning from one individual. If I have a DNA profile from evidence and I compare it to a known individual, if there's a difference at even one location, I can say it's an exclusion. If I have a mixture, it's not that cut and dry. I have to take into account how many people are in that mixture, how many pieces of information I have, is there potential dropout. So it's just because someone may not be present in a mixture doesn't necessarily mean that I'm going to automatically exclude them.
I see. At D19S, what was Mr. Twiggs's type?
It was a 1416.
Did you find a 16 allele in the 8A sample?
No, I did not.
Okay. At Tho, what was Mr. Twiggs's type?
He was a 79.3.
Did you find a 7 allele in the 8-1 sample?
No, I did not. But again, this is a mixture and there is some dropout. So just because I didn't see a 7, for example, does not mean I would automatically exclude someone.
It's a mixture, so there was some dropout. So did you assume that at that location that the allele that dropped out matched his allele?
At that location, no, there's only one individual represented there. So when comparing an elimination, I would essentially ignore that location. I'm looking at the other locations where there was 2 individuals present.
Okay. Now, a couple more topics and then we're done. When you received the evidence, you got more than 7 and 8, correct? You got a number of other samples.
Correct, I did.
You got a backpack, which you labeled as Exhibit 9, and a bunch of items from that backpack, correct?
Correct, yes.
You were initially told that those items related to things that may have been discarded by the suspect.
So initially, we didn't have any information. So we processed that. Those are items that are good for DNA. Not having any information from the investigators, we processed them for DNA. As the investigation continues, it was determined that that backpack was potentially left behind by a bystander, and there was no comparisons needed at that time.
Well, left behind by a bystander, or according to your notes at page 20, the backpack belongs to Kirk's detailees.
Yes.
How's that relevant? It wasn't determined to be related to a suspect. Ergo, it wasn't tested. Jesus, Pete.
It's based on an individual that was not my communication log. That was someone else within the laboratory. That was the information that they received.
Before you received any samples,
Trying to
did
make
you
a point where there is
request
none.
to perform what's called destructive testing on the samples?
Yes, I did. And destructive testing is essentially consuming the sample, cutting the cotton off of the Q-tip or the swab, subjecting it to testing. There's nothing remaining. I have to request permission to consume prior to doing so, and I did in this case.
And why did you do that?
That is part of our protocols, that we have to request permission to consume, and we consume, so DNA, we can't see it, so when an item is swabbed, we don't know how much DNA is on that swab, if anything, or how that swab was used. Did someone just swab using one side of it? Did they roll it and use all sides? Because I don't know that, it's our practice to consume that swab. It's our best chance of getting any DNA evidence.
And that's a determination that you made in this case before you even saw any of the evidence, correct?
Determination to consume?
Yeah.
Yes.
Okay. Now, remember I referred to that NRC report?
Yes.
1996. Did they say they're a wrongfully accused person's best insurance against the possibility of being falsely incriminated is the opportunity to have
Okay.
the testing repeated?
Fabrication
Such an
error.
opportunity should be provided whenever possible.
Yes, that does say that.
And does your laboratory have a policy, standard 7.4, which says, where possible, the laboratory shall retain or return a portion of the evidence, sample, or extract?
That is correct. And we do actually return the remaining extract, the liquid from our DNA testing. So we did consume the swab. However, there was a small amount of liquid that was left unreturned.
On some of the items, right?
I believe on all of the items.
We'll get to
He tried to make a point, and once again, he made a point where there was none to make because he failed to. And I know he's not done, but it's like this is why it's important to know what the fuck you're talking about before you try to make points. Because he tried to make a point about the swab, but she returned the liquids. Got nothing.
That in a minute. And that policy that I read is from your lab policy, right? The
Yes.
FBI's lab policy.
Yes, it is.
And then is there also a similar policy from the quality assurance standards, the FBI quality assurance standards, which says the laboratory must have a policy on sample consumption. The policy is expected to provide instruction for if and when the laboratory may or may not consume a sample and any documentation that the laboratory requires.
That is correct, yes.
Okay. Now, your report indicates that certain samples were destroyed, consumed, correct?
That is correct, yes.
And which samples were consumed?
Items 1 through 6, which were swabs from possible smudge, swabs of hand swipe, swabs from possible sweat drop, swabs from possible smudge, swabs of possible smudge, and swabs from possible sweat drop. In addition to items 54 and 55, which were swabs of swiped finger areas and swabs of stairwell railing.
Okay, so when you wrote in your report that those items were consumed, which of those items, and by that you mean the actual swab was consumed?
Correct. So a swab is just like a Q-tip. So the cotton portion of that swab was cut off the wooden stick, placed into a tube, subjected to DNA testing. So we consider that consuming. But again, there is liquid at the end of the process that is returned to the field.
And the normal procedure in terms of sample preservation would be something called sample splitting, right? You split the swab and you use half, you save half so that your testing results can be replicated and retested.
So yes, however, again, I don't know how an item is swabbed. So even if I were to cut that swab in half, it could be that I'm testing the half that doesn't have any DNA and the other half may have some DNA, or the swab may have a little bit of DNA on one side and a lot on the other side. So for the best possible chance of getting a DNA profile, it is our practice to consume the entire swab.
So for the first 6 items, those were swabs that were taken from the northeast corner of the Losi building, correct?
Correct, yes.
And you used all of the swabs, and you concluded that there was no DNA present on any of those items, correct?
That is correct.
So you couldn't do any comparative testing.
Correct. There's nothing for me to compare to.
Okay. And what did you have left after you did that in terms of the volume of extract? What was left?
So it was approximately 3 microliters, so a very small portion.
Very small portion. And you actually used 10 microliters to do your testing with those samples, right?
That is correct, yes.
So if you didn't get any results with 10, what you left over would not be sufficient to get any sort of independent testing done, correct?
It could be tested. However, my expectation, if I took 10 microliters and did not get any DNA, the remaining 3 would also still not give me any DNA.
Okay. And for item 55, that was 2 swabs of a stairwell, from a stairwell railing where the suspect touched the railing, right?
As far as I know, they were swabs from a stairwell.
And correct me if I'm wrong, but I understand from your lab notes that you took those 2 swabs and combined them into one sample and then used the whole sample, right?
That is correct, yes.
Okay. Before you did that, did you inquire whether the 2 swabs came from 2 different areas? For instance, maybe the suspect touched it here, but the other sample was taken somewhere else?
I did not. They were both labeled as coming from the same stairwell, and they were packaged together. So our policies and procedures is that we can combine those 2 together.
And when you do that, you create a mixture, right?
I don't know that I would agree that combining the 2 would create a mixture. Given the item of evidence, a stairwell railing, I don't necessarily expect that one swab would have one person, the second swab would have a different second person, and combining the 2 of them creates a mixture. However, I don't know that for certain. But again, I don't know is DNA present, so our procedure is to combine and consume those swabs.
Okay. And in this case, when you did that, what you got was a complex mixture, right?
I did. I got DNA from more than 5 individuals, so I could not provide a conclusion.
All right. Now,
Just lawyers trying to out DNA a DNA expert and looking like a dumbass. But that's just, typical. I feel like this is every defense attorney, so I can't limit Michael Burt. I can't narrow this down to Michael Burt, but I'm sure there's a reason why he is the one doing it. So
He's skilled in that field. I don't know of a Trump.
I'm pretty sure Kathy Nestor was like, I'm not doing that shit.
Yeah.
Even Kathy Nestor was like, fuck no.
Besides the Menendez case, I need to look and see what other cases he has handled. See what his field of expertise is.
I think he has no idea what he's doing. He's winging it. and he thought he had something. You know, he thought he had something with that towel.
He
You
thought that was
know,
smoking
he
done.
thought he had something with that towel.
He thought that was his Perry
Class
Mason.
has been quiet for so long. I thought he was eating or asleep.
No.
I still haven't eaten. It's been 19 hours. Last time I ate was 5:15 yesterday afternoon.
For real? You ain't. Wow.
I've had water, caffeine, and that.
Well, at least you have a couple hours before they start. They started at 3 o'clock.
Yeah, I have to change my stream. So, if it's too ridiculous for Nestor, how ridiculous is it? Well, let's just put it this way. He was
Nestor,
talking about the DNA on the towel and being so concerned with the roommate's DNA testing being exclusionary because he was the roommate. Were you aware that the towel was found in a bush? Notwithstanding the hilarity of towel meets bush, but
and apparently, according to reports from like the Corey Richards case, Nestor isn't good with stuff like this.
I don't think any lawyer is good with DNA. Because
You can make the argument. You can make the argument that Cruz in the Edric Faust case challenged the DNA, even though it didn't work. Because
yeah, he challenged the DNA. He wasn't good with it either. I mean, I agree more with his argument than anybody else's. But still, the way he presented it was like, you do not know what you're talking about. I agree with the premise on which you are trying to present it, but you are still trying to say words that you have no idea what they mean. It is like a lawyer trying to talk anatomy and physiology. It is funny as hell when you don't know what the fuck you're talking about. It's like a doctor trying to speak physical or occupational therapy. It's like, you don't know what the fuck you're talking about. It's like me wearing it's like me wearing a tag that says Heather, occupational therapy, and a doctor still calling me PT.
Only lawyer that's potentially good with DNA and stuff like that is Barry Scheck from California. Had the O.J. Simpson case, cross-examined their DNA expert for 8 days. Found the Innocence Project. He probably about the only lawyer that's good with DNA.
Yeah, I mean, there's a difference. I have to clarify. I think what I mean by not good with DNA. Like, I don't think anybody is actually good with DNA except for the people who work with DNA because it is a very complex science. Even in biology class, when we were going over college biology, when we were going through DNA and alleles and all that shit and what it meant, it took me reading the chapters like 4 or 5 times to figure out what the hell I was reading.
Yeah,
and I was like 24 years old.
When it comes to portion of trials that deal with DNA forensics, I'm like, yeah, this goes way up my head. I don't know.
However, there is a significant difference between talking about it, recognizing that you don't understand the world of DNA, and presenting it in a way that I don't understand this, but certain things aren't adding up to me. And I'm smarter than you because I'm a lawyer. And for some reason, Michael Burt just strikes me as that I'm smarter than you. It's Novak. It's Novak and him and Nestor, and I don't know why.
Maybe it's just California attorneys. Well, no, because Nestor Utah stuff.
But they strike me as I'm smarter than you because I'm an attorney, even though I have no idea what you do for a living.
Now, would you agree with the people? Because some people will argue that Alan Jackson is like that.
But Alan Jackson comes across as like, I don't understand what you do. Like, I don't understand the science. Yeah. However, certain shit doesn't add up to me, and I need you to explain it.
Yeah.
Like, it's a slight difference to me, but it's important. And Michael Burt is like, I'm going to tell you how to do your job.
Yeah.
Whereas Alan Jackson comes across as, I don't understand your job, but what I do understand doesn't make any fucking sense to me.
So make it
make sense. Like, You know what I mean? Like,
Yeah,
there's
yeah.
two
I know
different
people.
mentalities.
I know people
Of,
like he's arrogant. I'm like, I don't see that, but I don't know.
I think that's what it comes across as, is an arrogance. Like I know more than you because I'm a lawyer, even though I don't understand your job, versus like an Alan Jackson that is, I'm a lawyer. However, I might be smart in my area of expertise. However, I don't understand what the fuck that you do for a living. So please explain it to me. And just certain things don't add up. When you say this and you say this, there's something that doesn't, you know, like the car. It's like, well, you say that he was struck by a car, but the injuries that he had don't seem consistent with what I understand from a car injury, from, you know, like broken bones, lacerations, you know, bruising, things like that. Just, you know what I mean? Like, you're the expert, but like my common sense is telling me that something's not right here. Versus Michael Burt, who tells you how to do your job.
Yeah, just like it's like something don't seem right. So
For those of you who are vets who might be watching, apologize in advance for my reference if you're a certain person who fits into this reference. Alan Jackson is like the enlisted bro. Michael Burt is the officer who just graduated from college yesterday, but outranks you, even though you've been in for a decade.
yeah.
But because he's an officer, he thinks he knows more than you.
Yeah. And the difference with Jackson is he's seen it from both sides because he was a prosecutor and now he's the defense. So he's been on both sides.
But it's like, for those of you who were military, you understand that reference. You get that ensign. If you were Navy, you get that fresh out of college, fresh out of OCS. I know what I'm doing. You got to listen to me because I'm an officer, versus that like chief who's been in 15 years, who has been on 5 deployments, who knows what the fuck they're doing, knows how shit goes, but the officer tries to tell that chief how to do his job. Not gonna fucking work. Not gonna fucking happen. Fresh off the boat. No, brand new officer does not tell a salty old bastard chief how to do his fucking job. That's just not how that shit works. So I apologize if you happen to be a vet and you were one of those officers. But you know that shit is true.
A natural born leader.
You know that shit is true. You don't tell the chief who's been in for 15, 20, probably on his way out the door for retirement, how to do his job when he's been in longer than you've been alive. You know?
Mr. Burt, and we are at the 4:30 point. I just want to inquire, without applying pressure,
one
just trying to
area
understand. Okay.
Not trying to apply pressure. No, I'm going to apply pressure. Get this shit on the show on the fucking road.
Earlier about your testing of the length of the DNA sequence, the length of the DNA boxcars, not the sequence of A, C, T, and G within those sequences, within those boxcars, right?
Correct, yes.
And is it true that there are different alleles that have the same length when you measure by SDRs but have different sequences?
Yes, that is possible.
And I'd like to show you a chart that you have reviewed. I believe this is, could you bring up 34? This is not in front of the,
Oh man, we're gonna be in
On the
real
public service for the
time come
witness.
this afternoon.
and is this a chart that you reviewed, that I prepared to, and you looked at to see if I had correctly stated what alleles were found?
Yes, it is.
And does it, as it's presently existing, accurately state what the alleles are at each
Yeah.
location?
Yes.
Okay. I would move that into evidence. It's 5 pages and it's Baker 34.
Mr. McBride?
Prima facie showing of probable cause. This is irrelevant to the preliminary hearing.
Yes, I'm skipping. It's the same.
And this exhibit and the next one go directly to whether the comparisons being made between Mr. Robinson's sample and the evidence samples are usable and reliable to make a determination that he is a probable
Will he
contributor.
sustain it or will he overrule?
I'm not sure I'm following with what you're saying on there, right? And maybe it's just because it's late in the day. Could
Yeah,
you
it could
repeat
be.
that?
So
feel
this
like I
chart
don't
illustrates
understand what you're saying.
I skipped the objection because we all know what the objection is. It's
Yeah,
the same
not
one every
probable
time.
cause.
This is not
Yeah.
relevant to probable cause.
Allele she found at each location for Mr. Twiggs and Mr. Robinson, and for the evidence samples, the 71A and 81A. The other alleles are on here as well, but we're going to focus on 71 and 81. And for instance, Your Honor, at the, you'll see that under the first reading there is for Tyler Robinson at the D3 location, he is a 17. Okay? And take that down. And then if you go down to the 7-1 towel sample, which is what the topic is of
It's
this
the infamous butt
report
towel.
introduced by the state, you'll see that she found a 17 there as well, measured only by the length
Curly
of the DNA
teeth are
strand.
blue.
And what she's going to testify to is at this location and 5 or 6 others, there are alleles, all of which measure here 17, but actually contain different sequences. And that her testing that she used does not measure for those differences.
And so as it relates to probable cause, that's what I want to keep coming back
Sure.
to. Again, if this was a trial, this may be a little bit different analysis
Yeah.
that the trial judge applies, but as a magistrate, taking a look at this and looking at the probable cause standard, how does this comport?
So it comports because it goes to the ultimate opinion expressed in the report that the state is offering, that the report offers reliable support that Mr. Robinson is a possible contributor. And we're asking the court to consider that the comparisons are only based on a limited number of length-based comparisons, and that there are sequence differences so that she cannot distinguish, and I believe she'll testify, she cannot distinguish based on the testing that she did in at least 5 separate locations, whether the evidence sample and Mr. Robinson's sample, or for that matter, Mr. Twiggs' sample, matches the sequence differences here. And this is my final area, and I think I can do it very efficiently, and I think it is important for the court to consider, especially as it relates to the comparison to Mr. Robinson.
Mr. McBride.
And she is also going to testify that the analysis she does is based on looking at the totality and all of the different markers that match and are consistent, and that's how she comes to the opinion that she does. The point is, there are explanations that are susceptible to different interpretations and arguments. Ultimately, we're going to have an expert hearing where all of the literature is going to be before the court, and the court's going to determine if it meets the threshold of reliability for admission at trial. But at this stage, even granting that there may be some argument that may come from defense counsel's position, the court can't weigh it. This does not go to the probable cause determination, and I don't think it's relevant. And this exhibit in particular is not relevant without the testimony of the witness. And so the exhibit should not be admitted on its face either.
That's why I was trying to lay a foundation that she would, and offered a proof to the court that she would testify, that in fact there are these sequence differences at the 5 or 6 locations, 6 different locations.
The fact that he had to
relative
count
the
that-
comparison to Mr. Robinson. And when the state says the court can
I count
weigh,
on
the
my
court
fingers,
can weigh
so
reliability.
whatever.
The court has ruled that. So we're simply asking the court to take into account the limited nature of these comparisons and the fact that she cannot, based on the testing that she performed, tell the court whether there are differences between, at these 5 locations. She can't match Mr. Robinson to the question samples because she didn't do sequence testing. And she'll also testify that the FBI is in the process of implementing this kind of testing.
All right. Thank you to both sides. I'm going to allow the admission of this evidence, but I'm also going to set a limit of a limited number of questions. We are now at 4:40. This is on the cusp of whether it is applicable to the probable cause standard. I want to afford defense its full opportunity, but I still have to rein it in to keeping it to probable cause and not going into full exploration, because that's not the purpose of a preliminary hearing. So I will admit
You're getting
Baker
ahead of yourself.
34, but Mr. Burt, I'm going to limit you to how much time do you need to address
I just
this?
need about 4 or 5 minutes. The next chart will be the chart with the, what are called isoalleles displayed for the court, so the court can see what we're talking about, and that's it.
All right.
I'm just going to have her document that, in fact, I've accurately stated what the alleles are that have sequence differences.
All right, so it is Mr. McBride.
Just on a second matter, which is, I need to cross-examine this witness. She's got to leave town today. I would like 20 minutes to cross-examine the witness.
All right, well, we'll go with the, I accept Mr. Burt's representation's amount of time, and I'm going to talk less because that's consuming more time, and also allow the state the appropriate time for cross-examination given the nature of this witness having to travel. So, Mr. Burt, I'll turn to you. This has been moved into evidence. Do you want it on the screens?
She's a government employee. Girl, gotta get back to
Actually, I
work.
don't need it on the screen, just in the interest of
And
efficiency.
she's from
Collect them all.
Virginia, so that's not nowhere near close to Utah.
She's from your neck of the woods. She's from
I'm on-
Quantico.
Quantico, I believe that's about an
35.
hour or so away from me.
Yeah, not very
Take
far
that one down.
in
And is
comparison
this
to like
exhibit the same chart with what are called the isoalleles indicated?
Yes, it is.
And isoalleles is a term used to refer to these alleles that have different sequence but the same length.
Correct, yes.
So across the top there for allele 17 and D3, there is a allele 17A, allele 17B, allele 17C, all with the same length, but different sequences for each of those three.
Correct, yes.
And similarly at VWA, where you say that Mr. Robinson is an 1819 and 1819 in the evidence sample, there's an 18A, a 18B, a 19A, and a 19B.
Correct, yes.
And similarly for the other areas I've indicated there, I've accurately stated what the different sequence alleles are, correct?
Quantico, Virginia, is about
So I move this
53
as
minutes away from me.
and for publication.
Is this Baker 34?
Yes, 30.
Yeah, and please do all the YouTubey things, like hit the like button and share this out if you think that you need somebody to cover this with a little more drama and flair than like people in the mainstream, and even no offense to him, but people like Officer Tatum, who, bless his heart, he is a very Christian man and keeps a very like respectful nature, whereas I just tell it like it is. And I get a little salty, and we like the cursey words around here, which certain people don't use on their channel. So if you like the cursey words, stick around and share the stream out, because I use them all the time. And please hit that like button, because YouTube has throttled me back sharing these, because and limited my ad revenue because of the content of, they apparently don't want this shared.
Oh, no, all the other channels don't get struck. At least as far as I'm
Same
aware
objection,
of.
Your Honor.
Huh?
I said all the other channels who covering this, there's like 50 channels covering that don't get struck as far as I'm aware of.
Yeah, well, YouTube, I'm pretty sure, doesn't like the fact that I cover a lot of shit that I cover. So, yeah. Yes, the QR code is mine. That is my affiliate link for the Tell of Truth, because I like my skin looking like I am not 40 years old, because everything else feels like I'm 50. Everything else feels old except for my skin. So I use tallow balm on my face, on my skin. I use it for everything. And that is my link. If you use code SQUID at checkout, you get 12% off. What I put on my skin is very important. I don't like to put a lot of chemicals on my skin, because we all put a lot of chemicals in our body with what we eat and the standard American diet, which I'm working on cleaning up. But skincare is our skin is our largest organ. So what we put on it is super important, as well as what we put in our bodies. And
Note to self, stop
trying-
eating Bitmax.
trying to eliminate what I put, the amount of chemicals and petroleum-based stuff that I put on my skin. And tallow balm is all natural. It is basically rendered beef fat. And they have a whole bunch of products, from a face cream to a vanilla body whip, which is amazing. Smells like vanilla buttercream frosting. And it's I just love them. And they were the first company to take a chance on me when I reached out, and because I used this product before, I reached out and asked for a discount code, and they gave it to me. So I appreciate them very, very much. They are a small Canadian company who is non-woke. They don't, they are like me. They don't like big government. They say, just leave us alone, let us do our thing, and stay out of my life. And that's how I am with the government as well. So that's why YouTube doesn't like me very much. But, you know, on that note,
That could everybody else who covered this case is, with the exception of a few others, is talking about like it's all politics for them.
yeah, I don't know. I'm just like, it has an air of politics, but like I don't know. Like at the end of the day, somebody lost their life, and somebody's got to pay for that. And let's see what, instead of what the headlines are saying and what the conspiracy theories say, let's see what the evidence says. I'm just here for the evidence.
Everything I see streamed about the case, with the exception of like a few, like 3 or 4 to 5, all the other channels are talking about like, oh, I wonder what ramifications this going to have on the presidential election. I'm like, what are you talking about?
At the end of the day, Charlie Kirk was just a civilian. Yes, he had friends. One of his good friends is the vice president. In fact, the first show that was back on his YouTube channel after he passed away was from the not the Oval Office, but the vice president's office. The vice president was the host of his show the first day it came back. So he had friends in high places, but at the end of the day, he was just a civilian like you or I. So we need the same transparency. And yes, did things get put in as a priority in Quantico? Yes. At the same time, he's just a civilian, and I think that's where people are having the disconnect, is because he had friends in high places. They expect this to be a federal case when it's just a state case.
Now, I did find an article about 20 minutes ago that said Tyler Robinson's preliminary hearing may quell or quiet online conspiracy theories. That's like, I doubt it, but sure.
I mean, that would be the hope, because people would see some of the actual evidence, like the videos. There is no way someone could make it off the roof that fast. Well, you just saw it. You saw the video yesterday. You literally saw the video. That is someone running. Whether that's Tyler Robinson or not,
may be in dispute, but it's
yes, maybe in dispute. But that was an actual person running that fast and getting off the roof. You saw it. You know?
They say you gotta have some acrobatics or do parkour to get off something like that.
So the fact when someone says you can't get off the roof that fast, someone did. You saw it. Whether it's Tyler Robinson is yet to be proven. However, we literally saw a human run across the roof and get off the roof, walk across the ground or the grass and the concrete like he was any other student.
Yeah.
And try to look like he blended in.
Blended into the crowd, yeah.
So it was possible. So there's one conspiracy theory quashed, you know?
Yeah.
Yeah, even if he was a higher up, it might not be a federal case. For example, if California's governor were mortally injured in California, it'd like be a California case, not federal. Yeah. I think because he had friends in high places, the president was his friend, the vice president was his friend. I think people assumed instead of actually looking at the, you know.
Yeah, I ain't gonna lie. When I first heard about the case, I thought he was an elected official. Then I started actually reading about it. I'm like, oh, okay.
Yeah, and
well, I think
I have seen close-ups of the running person that looks like him to me. That as me as well. However, it has yet to be proven by a jury that it was him. So, but that was a person. That wasn't a
guilt.
Yeah. So it innocent until proven guilty. So conspiracy theories from people who actually watched it, because there will be people like my friend last night when he was talking about it. I'm like, you didn't watch yesterday. You didn't watch anything, because if you would have watched, you would have seen the video that literally showed somebody running across the roof and getting off the roof in about 15 seconds. We saw it with our own eyes. I don't know how much more I can say about that.
I still have friends like it's a government conspiracy. I'm like, no, it's not. You gotta watch the stuff.
Do I think some people in government wanted him unalived? Oh, possibly.
Like, yeah.
But at the same time, there are people on the internet that were celebrating his death. So like if there were random people on the internet on TikTok with millions of followers that wanted him unalived, and people with t-shirts on social media that say fuck Charlie, then yeah, of course there's going to be people in government who want him unalived too. But just because you want him unalived doesn't mean that you're actually going to do it, because there is a difference between wanting something to happen and actually doing it. Yeah.
All right, I'll admit into evidence under the previous statement as it relates to Baker 34. It may be published.
Now, I hope he stick to these limitations, because this is getting ridiculous.
Oh, look, there's his ugly face.
And as you look at these 5 areas, you can't distinguish the evidence samples from Mr. Robinson based on the sequence differences, can you?
Correct. I only utilize length differences, STRs in this case. The FBI laboratory does not use sequencing for nuclear DNA testing, nor am I qualified in it.
Right. What is NGS?
NGS stands for Next Generation Sequencing.
And your laboratory is involved in validating next generation sequencing, correct?
We utilize next generation sequencing for mitochondrial DNA, which is a different subset of DNA testing, but not for nuclear DNA testing, which is what we're talking about today.
Right. But the people who market STR mix also market a sequence platform, do they not?
I'm not aware if they do or do not.
Last question, take a look at.
Last question of this. Hot pickle. Last question.
Thank you.
All right, turning to the state.
He didn't ask
Mr.
another
McBride.
question. FYI.
Cross examination. And more like directed.
Good afternoon.
Good afternoon.
Come on, don't pull a Kathy Nestor. Drop your shit all over the place. Sorry,
I
we
wanna
haven't
start by
seen her
asking
this
you,
afternoon, but
what your training and experience is. First of all, do you have any education?
Yes, I do. I have a Bachelor's of Science in Biology from Salisbury University.
And do you, after your bachelor's in biology degree, what did you do for your career and in further education?
Upon graduating from college, I began working at the FBI laboratory as a contractor. I was assigned to the Federal Convicted Offender Program, which was a program under the DNA unit. During that time, I did that for approximately a year and a half. It was my responsibility to open and inventory and barcode DNA collection kits sent in from federal agencies across the United States. I then became a biologist in the DNA casework unit. I did that for approximately 6 years. During that time, I did the actual testing of items of evidence, so swabbing, cutting those swabs, producing the DNA profile. And then in 2015, I accepted a position as a forensic examiner, which I am still today.
I'm sorry, what year was that?
2015.
So 11 years you've been doing more or less the same duties you have now, is that right?
Correct, yes.
I want to ask you about your lab's accreditation. What is accreditation for a laboratory?
Accreditation is a formal recognition that our laboratory is following a very strict set of standards. We're accredited by ANAB, the American National Standards Institute National Accreditation Board. And our accreditation shows that we have to follow standards such as I have to have a certain education background, how we process evidence, how we store evidence. Every 4 years, we're audited to those standards, meaning an outside body will come into our laboratory, look at my training records, look at our standard operating procedures to ensure that we're following those standards.
same thing with hospitals.
And you mentioned
Okay.
your training. So what do you have to do as an examiner there, as a scientist there, for your lab to maintain its accreditation?
So for my training program, I had to complete a 2-year training program. During that time, I learned the science behind DNA testing, and I showed that I understood that science by completing oral board examinations and written examinations. I also then had to show that I could relay those scientific results to a jury by completing moot court exercises. And before becoming qualified, I then took something called a competency exam, or it's like a final examination to show that I'm qualified to perform my duties. During that accreditation or that audit process, my training records were reviewed to make sure that I had the proper coursework, the proper college degree, as well as completing successfully that training program.
And do you have to keep up with ongoing education to maintain your, you have certification?
I'm not certified. I'm qualified as an examiner.
To maintain your qualification, do you have to have ongoing education?
Yes, on a yearly basis, I have to complete at least 8 hours of continuing education, and this can be done by attending conferences or lectures or reading scientific literature.
Do you also have to undergo proficiency testing?
Yes, and a proficiency test is a test that we receive from an outside vendor. I process that test like I would any other case and submit that those answers to determine if I'm satisfactory or unsatisfactory. This tests not only me to see if I'm still proficient in my qualifications, but it also tests the laboratory process to ensure that we're getting accurate and reliable results.
Now, as you discussed your work in this case, you talked about your work needing to be reviewed by another analyst.
Correct, yes.
And is that true in every single case?
Yes, in every one of our cases, they have to undergo a technical review in addition to an administrative review.
And it sounds like during those technical reviews and administrative reviews, there's discussions between you and other analysts. Is that accurate?
Yes.
And is that an opportunity for training and learning as well?
Yes, absolutely.
And I assume that training and learning goes both directions, that you're learning and you're also helping others understand your thought process, which may train them as well. Is that accurate?
That's true, yes.
The tools you use, are the tools you use validated?
Yes, they are.
And what does that mean to have a tool that you use validated?
So a validation is a thorough testing of a process or procedure. So before we subject any evidence to testing, we ensure that those process and procedures will work within our laboratory. Based on the validation, we create something called standard operating procedures, or SOPs, and these are kind of like cookbooks. It gives us step-by-step instructions on how to do our process and procedures. And then both myself as an examiner, as well as the biologists, we're all trained to those standard operating procedures and tested to those standard operating procedures during proficiency tests.
Now, you've talked about, I think, a couple of the tools you use. One you call StarMix, is that right?
Correct, yes.
And is that tool validated?
Yes, it's validated both developmentally and internally. Developmentally it's validated by the creators of the software, and then we, the FBI laboratory, also tested StarMix to ensure that we could use it within our laboratory and produce accurate and reliable results.
Now, when you say it was developmentally validated, is that in a peer-reviewed study?
Yes, it is.
And is StarMix used? How widely is StarMix used throughout the world?
StarMix is used in approximately 120 laboratories, both domestically and internationally.
Well,
I want to go back to some of the questions you were asked on direct examination. You were
go ahead.
asked about an Exhibit 8.4, Baker 8.4, which is the DOJ Ultra, which is the Uniform Language. What does that stand for?
Uniform language for reporting and testimony, I believe.
Okay. It talks about language that you should use and language that you shouldn't use as an examiner and a scientist, correct?
That is correct, yes.
Now, I want to ask you a little bit about what you do when you have a conclusion, like you did in Exhibit 31. Do you know? Let's see. The directive from the Department of Justice limits the adjectives you can use to describe the evidence and the conclusions that you reach. Is that accurate?
Yes, it is.
And the thinking behind that is to submit the statistical number and let others decide, meaning the reader decide how they want to describe that number. Is that accurate?
Yes, it is.
So, for example, if we can look at Exhibit 31, if you don't mind publishing that. Yes, and that's been admitted, so if we can put it on the screen. From the rifle. We have the number in a written form in the second paragraph beneath the heading, and then beneath that you have a table, correct?
That is correct, yes.
And the likelihood ratio gives the number, right? That's the likelihood ratio. And that's stated in sentence form in the paragraph preceding the table, correct?
Correct, yes.
The only language you can use to describe what that number means from the DOJ directive is very strong support for inclusion, correct?
Correct, yes.
And the sentence there that says the DNA results from item 7.1 are 1.7 octillion times more likely if Twiggs and T. Robinson are contributors than if Twiggs and an unknown, unrelated person are contributors. The reader can assign whatever value they want to that, correct?
What do you mean?
Meaning adjective to describe what that means.
Sure, yes.
The adjective you can use is very strong support.
For inclusion, yes.
Okay, for inclusion. All right, if we go to 8.1, Kimberly, if you can scroll down just to make that a little bit easier to view. Same question there. The results are from 8.1 are 30 quintillion times more likely if Twiggs and T. Robinson are contributors than if Twiggs and an unknown, unrelated person are contributors. The adjective you're allowed to use is very strong support for inclusion again, correct?
Yes.
Okay, we can take that exhibit down. Thank you. You were asked about formal activity level, and you described this as the lab cannot testify about, or you cannot testify about what action left the DNA on the object. Is that right?
That is correct, yes.
Does that mean that an individual did or did not touch? Well, let me ask you this. How
right.
can DNA get onto an object?
DNA can get on an object via direct contact, so an individual touching an object. It can also end up on an item via body fluids, such as blood, or through transfer. So if I were to touch an object and then that object is given to someone else, my DNA could potentially be on that other individual through the transfer of DNA.
And your lab can't, or you cannot testify as to what precise action left the DNA on the object, correct?
Correct, I cannot.
Okay. Same question about time. You can't testify about the exact time that DNA was left on an object.
I
right?
like
Correct.
where this is
But
going.
there are some indicators that may give some information about how long and the conditions under which an item,
Yeah, you
under
get
which
right to the point,
DNA
too.
was placed on an item. Like, Degradation.
Bit of a slow start.
Yes,
but-
degradation or the condition of the item. So again, if a firearm, for example, is in a river, I would expect with the water rushing over that item, I may or may not be able to detect DNA. Also, if there's an item of evidence that is exposed to the elements, something that's been left behind 10 years ago, I don't necessarily expect to recover DNA, but something that may have been left yesterday, I might be able to detect DNA.
An item that has been left in the dirt or has been rubbed in the dirt, could that affect your ability to recover DNA?
It could, yes.
Could it also affect degradation?
Yes.
Can UV rays affect degradation?
Yes, it can.
So this item was recent.
Does degradation keep you
Because
from
there's a lot of
doing your
DNA.
work?
No, it does not.
Is degradation normal?
Yes, it is.
Does all DNA degrade?
It does, yes.
I imagine if it's kept in a pristine environment, it would degrade less than if it's kept in or if it's found in a less or out in the open. Is that accurate?
Yes.
You said with regard to the screwdriver, there was some degradation. Did that affect your ability to reach conclusions in this case?
No, it did not.
You said on item 7, the towel, or the swab from the towel, there was slight degradation, not as much as Exhibit 8. Is that accurate?
Yes.
Did that degradation affect your ability to reach a conclusion here?
No, it did not.
No.
You're asked about a PCAST report. You testified that that gave guidance on different areas of forensic science. Do you know what year that report was published?
I don't recall the year.
Do you know if it's been within the last 5 years?
No, it is not.
Meaning it's older than that?
Yes.
Do you know if it's been the last 10 years?
I think it was 2016, but I'm not entirely sure. I would say within the last 10 years.
Let me ask you this. Has the science in your area, can I refer to it as probabilistic genotyping?
Probabilistic genotyping is the math in my area. Yes.
The science in your area and in your field, has it developed over the last 10 years?
Yes, it has.
And have there been studies that have made suggestions which have been implemented in the field?
Yes.
You testified about Exhibits 7 and 8, that they both had mixtures. Excuse me. Yes, items 7 and 8. In your testing of these items, that they both had mixtures. And you stated, I want to make sure I understood this. You stated, I believe, that the minor contributor was less than 20%, and that it was actually 5%. The ratio was 5% to 95%.
For one of the samples, yes.
Do you remember that?
Yes.
Does that mean the 5% was from Twigs, and the 95%, that 95% is assumed from the Robinson?
When I calculate the statistic, Twiggs' DNA profile aligned with the 5% contributor, and Mr. Robinson's DNA profile aligned better with the 95% contributor.
Okay. Same question with regard to 8. I think you said the
So
ratio is
5%,
11% from the minor and 89% from the major.
Yeah, 5%. They were trying to make it sound like
His DNA with the majority
5%.
on every. Yeah.
5%. These prosecutors ain't playing. Like, these prosecutors are not playing. Well, okay, let's put it this way. This prosecutor is not playing. This is by far my favorite prosecutor because he's straight to the point. He asks specific questions and he lays it out like I would. Like,
I believe this is the one that was held in contempt too.
no, the one that was held in contempt was the actual the lead prosecutor. The older guy. The one who testified.
Yeah, two of them got held. McBride, is that McBride?
Oh, this is McBride.
Yeah, so him and what the Utah County Attorney.
Yeah,
Yeah.
the not the actual elected attorney, but the other guy.
Yeah.
So this is McBride. The one who was held in contempt was the guy who actually was doing the talking. Not the elected attorney.
Is that Twigs being the 11% and Robinson being the 89%?
Yes, Twiggs better aligned with that 11% contributor, and Mr. Robinson better aligned with that 79% contributor.
You're asked about Baker 4, an exhibit that was titled Baker 4 365. Do you remember this exhibit by chance? I don't have a copy of it, so, well, do you have Baker 4 365? Put that up. And item 7 is the towel, right?
Yes.
Item 8 is the screwdriver.
Correct, yes.
Thank you. You know, in reaching your conclusions, did you follow the protocols of your accredited lab?
Yes, I did.
And based on your training and experience in following those protocols, did you in fact come to the conclusions described in Exhibit 31?
Yes, I did.
Thank you.
I feel like he wanted to go so
Mr.
many
Burt?
more places, but he didn't.
And how much time are you anticipating?
Examination to your training and experience, right?
Yes.
Do you agree with the statement in the PCAST report? Experience or judgment
You know, I
cannot be
thought I
used to
liked them in
establish
the
the
question
scientific
tape,
validity
but-
and reliability of a metrological method,
Here,
such as a
stuff is
forensic
dull.
feature comparison method. Moreover, a forensic examiner's experience from extensive casework is not informative because the right answers are not typically known in casework, and thus examiners cannot accurately know how often they erroneously declare matches and cannot readily
What are you
hone
talking
their
about?
accuracy by learning from their mistakes in the course of casework. Do you agree with that statement?
I don't. I think experience, they're right in the fact that we never know the true answer. However, my experience means that I've seen a lot of different DNA. I've seen a lot of validation data, so that does help me come to a conclusion.
Do you agree with this statement? By that same report, good professional practices, such as the existence of professional societies, certification programs, accreditation programs, peer-reviewed articles, standardized protocols, proficiency testing, and the code of ethics cannot substitute for actual evidence of scientific validity and reliability.
I don't think I agree with that either. The science has been heavily validated and tested to show that's reliable. Following protocols that are based on validation, again, shows that my results are accurate and reliable, as well as being proficiency tested.
By the way, you said that that report was not authored by experts, but the head of that group was Eric Lander, who is one of the foremost experts in the area of forensic biology, is he not?
That name does not ring a bell. I don't know who that individual is.
You don't know who Eric Lander is?
No, I do not.
Okay. When did you go to school? What years?
2003 to 2007.
What do you know?
You said that STR mix was widely used and then it's been validated. The PCAST report said the problem is it's been validated by the people selling the product, right?
Developmental validation, yes. Internal validation, no. A laboratory that's going to utilize STAR mix has to validate within their own laboratory.
And the PCAST report said that we need validation data not by the people selling the product, but by independent scientists in order to make this reliable, right?
They do, and that's exactly what happened. There was 31 laboratories that came together in response to the PCAST report and gave their validation data on how they internally validated STAR mix.
And then after that information came forward, the PCAST committee reviewed it, and they said PCAST was unpersuaded by those studies. While likelihood ratios are a mathematically sound concept, their application requires making a set of assumptions about DNA profiles that require empirical testing. Errors in the assumptions can lead to errors in the results. To establish validity with a range of parameters, it is thus important to undertake empirical testing with a variety of samples in the relevant range. And they specifically address the studies you're referring to, did they not?
I believe they did, yes.
Yeah. And then lastly, you said that STR mix is widely used, but as I understand your testimony, you didn't use it and rely upon it for your conclusion about twigs, right? The software told you there was no support there for including them, and you ignored it and decided otherwise, correct?
I did not ignore it. Again,
He's
given the type of
argumentative.
sample,
Holy
it was an
crap,
elimination sample.
argumentative.
I compared that individual to the DNA profile that I developed and determined that I could conclude that I could utilize him as an elimination sample.
You said your laboratory was accredited, correct?
Yes.
But you're aware that in 2004,
This is the
the Inspector
1990
General
style
did
memorial. You
a
don't
comprehensive
keep up
audit
to date.
of your laboratory and published a report called
prefer
the
this,
FBI
actually.
DNA Laboratory
Oh, okay.
Report, a review of protocol and practice.
So I think he's off base with how he's being argumentative because the questions he's asking are just dumb and why he's being argumentative. But if he would have been this way with like straight to the point, I think the reason I prefer the argumentative style is because it's straight to the fucking point.
Yeah. I'm about to send you some classic cases because that's you see that more commonly back in.
Well, I think it's straight to the point. Because when you want to argue, you want to get straight to the point. You don't go, Flash fan, well, what about this? Well, no, you're like, Flash fan, why did you do this? 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 You're straight
I
to
will
the
say
point.
back when he was in his heyday, his younger days, you say you don't like what if anything. The question back then, it's true or is it not? They always use that phrase. Back
It's not that I don't like what if anything. I think what if anything is overused, and I have PTSD, jokingly PTSD, from I get flashbacks, horrible flashbacks to Judge Ascarati going, you can't use what if anything to make it a non-leading question. Every time I hear what if anything, I see Judge Ascarati's face and Elaine standing at her desk like this, pissed off because she can't figure out how to ask a freaking question as an attorney. That right there is why I don't like what if anything. But it has a place. I just get very bad flashbacks to 2022 because of it. We're almost done with this. We have 2 minutes left, and then we are taking a break. And I am probably not going live until like 4.
Okay, cool. I get
So-
to squeeze a little nap in after lunch. Then.
Yeah, we're going a little nappy nap because we're 4 hours into this, almost 4 hours into this.
Abilities, which found a number of errors in the way that your lab does testing, correct?
Objection. The 2004 study is hardly relevant to this proceeding 22 years later.
It's relevant because he's relying on accreditation to somehow say that these results are valid. This lab was accredited when this study was done.
I'll allow this single question. She may respond. So I'm overruling the objection, and then we'll continue to move forward.
You're aware of that study, right?
No, I'm not.
Okay, thank you. That's all I have.
All right. Anything further for this witness?
It's a mom.
Yes, I think there's one follow-up that needs to be asked. You were asked that, or you testified that you never know the true answer with field work, correct?
Correct, yes.
And that's compared to ground truth studies where you do know the true answer and you can compare the conclusions that analysts draw with the true answer, the ground truth answer that is the basis of the study. Is that right?
Yes, and that is what our validation is.
Your validation actually is a ground truth test in essence.
Yes.
It's not.
Anything further for this witness?
Thank you.
May this witness be excused.
Yes.
Thank you, Ms. Baker. You may step down.
Thank you.
Tomorrow at 1 p.m., we do not have morning court for this proceeding, and we'll start up at 1 p.m. in the afternoon.
See, he did it 1 p.m. in the afternoon. Ugh. So 1 p.m. is not for another
Yeah, that's 3
2 hours.
That's 3 p.m.
3 p.m.
Eastern
our time.
Yeah.
So I'm probably not going to start till 4. I do have us set up to redirect over to Spawn Trooper. He is live right now, and I will see you guys over there
I'm
because
gonna eat a snap.
yeah. So yeah, that's a thing. So, but I have to let's see. Actually, we're not going to do that right now.
Oh,
Delete that. There we go.
only thing you might not have liked about the classic trials is that there's multiple recrosses and redirect examinations.
Yeah, well, stuff happens. Anyways, we are flash fan. There we go. All right, guys, I have a setup to redirect over to Spawn. Go give him a like and a follow if you don't. Thanks for everybody for following me over here on YouTube and over on Rumble. I appreciate you guys so very much. I'm going to go cook dinner so that when the
Stop.
dude gets home, it's done and just needs to be reheated. Because I haven't eaten yet, and it's 1:20, and we are on 20 hours, 22 hours. I don't know. My phone died. She killed the battery in my phone, so I'm also going to go throw my phone on a charger.
You look for the time. It's 1:20 p.m.
Yeah, well, I don't know how long it's been. 5:15 p.m. to 1:20 p.m. It's been about 19 hours, 20 hours since I've eaten. So we're gonna go cook dinner.
Yeah, you gotta go get some food and sustenance.
All right. The little is showing off her blue tongue from her ring pop, and we are gonna go tell Spawn I sent you, and have a great day, everyone.
Bye.
Say bye.